For reasons mentioned in the judgment, the instant civil division is hereby dismissed.
Deeply obliged.
I have delivered the justice.
Obliged.
May I please, your lordship? With concern from the other side, I beg to mention item number 7, my lord. I'm appearing on behalf of Mr. R. Dubey. His father has expired, my lord. Finally, 2 weeks may granted.
Item number 7 on, what is your name?
Mr. A. and I Hussain. I'm appearing on behalf of Mr. R. Dubey.
Mr. A, heard Mr. A.
And I Hussain.
N.I. Hussain submitting on behalf of Mr.
R. Dubey.
R. Dubey, learned counsel for the appellant, who prays for an adjournment for 2 weeks on the ground that the conducting counsel
Yes,
is in bereavement.
Yes.
Somebody has expired,
Yes, my his father.
is in bereavement. He has also obtained the consent of learned counsel for the respondent side, who has no objection to the prayer made by the counsel. Stop. In view of above, the prayer is allowed. Let this matter be listed after 2 weeks.
May it please, Lordship. With the concern of the other side, my lord, I would like to beg to mention item number 8 of today's list, my lord. Senior counsel, B.D. Mojumdar was engaged in this case, my lord. Kindly adjourn this case and fix a date, my lord, on 21st of
No fixed date. Registry will fix it. Heard Mr.
Shiladitya.
Shiladitya, learned counsel for the appellant, who prays for an adjournment on the ground that the engaged senior counsel has some personal difficulty today. He also submits that he has informed learned counsel for the respondent side. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Lordship. Lordship.
May I please, your lordship? With the consent of the other side, I beg to mention item number 17, lordship. Lordship, kindly adjourn for the day. And for the petition, lordship.
Heard Miss
R. Dev, on behalf of S. Chauhan.
R. Dev submitting on behalf of Mr. S. Chauhan, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel. She also submits that she has informed the learned counsel for the respondent regarding her prayer for adjournment. Considering the grounds mentioned, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged, lordship.
May I please, your lordship? Beg to mention, lordship, item number 12, lordship.
12.
Lordship. Hearing matter, my lord. In this matter, my lord, Mr. H. Gupta appears, my lord. He had to leave, my lord, out of station. In this matter, my lord, this file brief has to be reconstructed, my lord. That we have received, my lord. Can we, for a week or two, my lord, can be fixed on another hearing date, my lord?
Heard Mr.
Why Borbhiya, my lord?
Y. Bordoloy.
Why Borbhiya?
Y. Bordoloy. Submitting on behalf of Mr. H. Gupta, learned counsel for the learned assistance SGI, appearing for the appellant, submits that as the conducting counsel is out of station, an adjournment is prayed for. Who is for the other side? No one is appearing.
No one is appearing.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
My lord. I'm obliged.
May I please, your lordship? Lordship, I beg to mention item number 14 and 19. CGC counsel, Mr. S.K. Mitchell, out of station. So kindly.
You have informed the other side.
Yes, taken consent of this.
Heard Miss, what is your name?
M. Borman,
Heard Miss M. Burman, learned counsel for the appellant who prays for an adjournment on the ground that the assistant SGI, Mr. S.K. Medhi, is out of station. She also submits that she has informed about her prayer for adjournment to the learned counsel for the respondent who has no objection to her prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks. 14 and
16 August, Lordship, that means
no date. On after 2 weeks,
After 2
on a
weeks.
date to be fixed by register.
oblige. 14 and 19.
14 and 19.
May it please your lordship, I beg to mention item number 3, lordship. Lordship, kindly pass over for the day, lordship.
Heard Mr.
A. Sharma.
A. Sharma,
Yes. I am appearing on behalf of YS Mannan.
appearing on behalf of Mr. Y.S. Manan, prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed again. When?
Lordship, after 1 week.
Listed again on August 14th.
Oblige, lordship.
Wait, please, your lordship. This is a transfer petition, your lordship, from Tinsukia to the Court of Line and District Judge, Tribunal, lordship. In the last occasion, lordship, the respondent did not appear. Your lordship, if I may proceed today, lordship. Though the service is completed, lordship.
Who are you, husband or wife?
Our wife, lordship.
What is your case?
Lordship, my husband filed a title suit for divorce, lordship, in Tinsukia District Court, and lordship, but I am residing in Dibrugarh with my cousin and along with my parents also, because my
Tinsukia and Dibrugarh are not far away. What
lordship,
is the distance?
1 hour maybe, lordship.
You can go to the court.
Yes, but lordship,
What is the difficulty?
financially, the husband is totally not providing me anything, lordship, and because of the expenditure and lordship, moreover, my mother is a psychiatric patient, and I have to be with her, lordship. It is bit difficult the petitioner to go to the Tinsukia whenever the date.
No, how it is cumbersome if you go to Tinsukia and if the case is pending in Dibrugarh, what is the difference? 1 hour difference only.
1 hour difference, yes, lordship. But lordship, we
How
have,
you have made out your case for transfer?
lordship, that I have stated in paragraph number 5, page number 5, lordship. Paragraph number 5. The last question, the petitioner further states that since the opposite party has.
When the respondent has filed the divorce suit,
Yes, lordship, that is on 7/6/16, lordship,
7/6/16,
16.
at what? It is now 8 years.
Yes, lordship.
Since 8 years it is pending. What has happened? At what stage it is pending?
Now it has been stayed, lordship, because.
By this court's order.
Yes, lordship.
When it was stayed?
This it was stayed on lordship. 9/1/17.
Okay.
Since the service was not completed, so Lordship, the matter was
And you are residing separately from your husband for
No.
this.
residing in Dibrugarh, Lordship, with my cousin and with my parents also, because my mother is undergoing a treatment. She is a psychiatric patient also. That is why I'm staying in Dibrugarh.
Where the marriage was performed?
This at Dibrugarh, Lordship.
Have you settled?
Yes, Lordship.
Have you resided with your husband at Tinsukia at any point of time?
Yes, Lordship.
You have last resided at Tinsukia.
Decided at Tinsukia, yes, Lordship. My only prayer, Lordship, since he has stopped providing the basic needs, basic payment, and also, Lordship, the only submission is to transfer the case to the Dibrugarh so that I can, without any difficulty, I can appear, Lordship.
You have any child?
Yes, Lordship.
What is the age?
First, Lordship, at that time, he was 16 years, in 2017, by that time, yes.
Mother is a witness.
Sorry. Mother,
Your mother is a witness in your case.
Lordship.
No, how mother's ailment is related to your case?
Lordship, I have to take care of her, I have to be with her.
Okay.
Because there's no one in my house, Lordship. My father is a street vendor and because of the basic needs also, Lordship, I have to be with. I have also stated in piece number 6, Lordship, that there is no one in the family who can accompany the petitioner while going to Tinsukia. And therefore, it is very difficult for the petitioner being a lady to go to the Tinsukia alone to the contest the suit filed.
What is your age?
Lordship. Age.
16 years. Now, why you need a company to go to Tinsukia? There must be some reasons. You have to reason it out. Why a lady needs company?
Lordship.
So what is your submission? You have to persuade this court that for this reason, she cannot go alone.
Definitely, Lordship.
What is your submission? Otherwise, this will be dismissed. You come prepared. We'll take it up tomorrow or day after tomorrow. For transfer merely because it is proceeding ex parte, you cannot assume that it will be allowed. You have to give reasons for transferring of this. When the distance is not much, you
Yes.
find out something which helps you. I'm adjourning it. Heard Miss M. Nirola, learned counsel for the petitioner. No one appears for the respondent, though the notices were duly served on the respondent. Stop. This case shall therefore, proceed ex parte against the respondent. Let this case be listed again on. When do you want?
Friday, Lordship.
on 9th of August for admission hearing.
May I please your lordship? Lordship. Lordship 438 application, my lord. My lord, I was protected with an interim. I appeared after my interim order, my lord. The case diary was told for, my lord.
Case diary has appeared.
Yes,
And
yes, they
correct.
received lordship, but that part I didn't get because whether they appeared or not. It is up to date, though it is up to date up to your this 8 or 6-8 last to কেতিয়া দিছিল interim to কেতিয়া দিছিল
Interim 17 May.
17 May
When have you appeared?
My lord, on after interim order, my lord, that date I have not, my lord, but I know that within 3 days, 3-4 days, he has appeared. My lord, what happened was that in this matter, the day we got interim, maybe the prior day, the IO, he was leaving because someone was beaten or like some issues were there, the IO was transferred somewhere. So the OC was in charge of the case. He went more than 3 times, my lord, that I know. Because I used to get called whenever he used to go there.
Lordship, last because in the month of May it is only up to date up to 9-5 and in the middle there is 24 again 6-8 is there. But lordship, I didn't get the name of the accused petitioner in this from any other statement in any way. Even he is not FIR name accused. But regarding that record, being the statement 161 statement, that is not available because
as per my information, my lord, the IO of the case, because of some public reasons, he was like under divorce and then there was transferred. The OC was in charge for several months. May episode
no.
But you are not on bail.
My lord, I was on bill. I appeared. I was for more than 3-4 days.
Whether
I appeared.
you are allowed, you punish bail bonds.
He used to meet the OC.
But you were not arrested. You were not,
With his bailor, he used to go.
but you were not arrested and no bail was.
The original copy of the certified copy to the OC also, because there was
But
some.
whether bail bonds were accepted by.
Nothing is there. Lordship, the last in the month of April it is month of May 9/5/2024. This up to date. But lordship, here we didn't get the name of accused petitioner in anywhere in any statement. Even not FIR. But that part is not
It's
available.
my lord 9/5. My one is 17/5.
17/5 and there is on 2024 9/5 and latest is 6/8/24.
And whether there was attempt to arrest him. Anything.
That is not found. Even his name is not found. in
But
any
police
statement.
went there.
My lord, police.
Therefore, they have it. approached.
My lord, my submit.
So we'll dispose it off, make
Yes.
it absolute.
Yes, Lord. Yes,
If
Lord.
you want to arrest. He is already on bail. Protection is.
Yes, yes.
If you are arrested, you will be granted bail by the court, by the arresting authority. Heard Miss S.G. Barua, learned counsel for the petitioner. Also heard Mr. K. Bush, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 17/5/2024, the petitioner Razak Ali was allowed to go on interim bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the police on more than one occasions. On the other hand, learned additional public prosecutor submits that though the case diary of North Lakhimpur PS case number 56/2024 is available. However, there is no endorsement in the case diary showing that the petitioner had appeared before the investigating officer. He also submits, learned additional public prosecutor also submits that in the case diary, nothing incriminating has been found against the present petitioner. Stop. Considering the submissions made by learned counsel for the parties as well as materials available in the case diary, the interim bail granted to the above named petitioner by order dated 17/5/2024 is hereby made absolute with condition number 2 attached to the said order remaining intact.
My lord, there is a mistake in my part. Lordship, it is in the petition, it is stated as Razak Ali. But Lordship, in the case diary, it is the 6/8/2024. It is stated that Abdul Razak. But the Abdul Razak, it is a son of Gajibur Rahman. And other address is same.
Okay, what is the statement?
The statement is that Lordship, it is like that, এজন ভুক্তভোগী সোয়েনসো খুটপুচ কৰি গম পোৱা গ'ল যে আব্দুল ৰাজাকে সুৰুজ আলীৰ গাড়ীখন ভাড়ালৈ নি বিক্ৰী কৰাৰ কথা প্ৰকাশ আছে। আব্দুল ৰাজাক আৰু জিয়াবুৰ ৰহমানক কৰায়ত্ব কৰি
But nothing is there against Razak Ali.
yes, but here it is stated as not Razak Ali, Abdul Razak.
Okay.
But
এই
son of
লাইনটো
Sohail.
আছিল যে the learned additional public prosecutor submits that nothing incriminating. Read that line. Comma, however, there is an endorsement against one Abdul Razak, son of
Gajibur Rahman,
Gazibur Rahman in the case diary.
village Rongajan Borbil.
Stop. Thereafter, it will remain as it is.
Obliged, my lord, highly obliged.
Lordship, this I is for condemnation of delay, and notice has been served upon the respondents. But on the last occasion, they have not appeared, Lordship. So today matter has been fixed, Lordship.
How much delay?
561 days delay, Lordship.
561 days.
Lordship. Only thing is, Lordship, the claimant has filed the claim petition before the tribunal Karimganj, Lordship, for death of late Avinash Roy. For the death of same person, Lordship, two claim petition has been filed in two different districts, Lordship. One at Karimganj and one at Silchar, Lordship.
What has happened?
In Silchar, that was filed in the year 2014, Lordship. And that case was settled in a local Lordship. I have stated in paragraph number 6, Lordship.
Two settlements were made.
No,
Two awards were made. Okay, in Silchar, it was settled
It was settled,
in Lok Adalat. And
at Karimganj, Lordship, there was also compensation actually awarded, Lordship.
to the same claimants.
For the same claimant, Lordship. Okay, thereafter, Lordship, when the file was scrutinized, Lordship, the claimant insurance company got to know that two claim petitions was filed, Lordship. Thereafter, in the Karimganj, Lordship, we have filed review application at paragraph number 6, Lordship.
Who filed review? application?
Insurance company, Lordship.
Okay.
Insurance company has filed, that was partly allowed, Lordship. I've stated in paragraph number 7, Lordship. May I kindly see?
Paragraph
Paragraph 7, Lordship.
of
IA. May I read, Lordship?
Justin.
The MSC case number 46 of 2015 has been filed before MSC Karimganj. And finally, the member of the tribunal passed the judgment on 7/9/2018 and awarded compensation of rupees 9,80,625. During process of making payment
Compensation to whom?
to the claimant, Lordship,
Who was the claimant in MSC 46?
wife and children and mother, Lordship.
Okay, then
And
they,
in Silchar, Lordship, the case was filed, say, claiming themselves as the wife and children, Lordship.
Okay.
Thereafter, review petition filed, Lordship, that was allowed by order dated 29/2021. And that was partly allowed, Lordship.
Review petition in MSC 46.
Lordship 46.
You are seeking to file appeal against which
Against Lordship, order dated
MSC
7/9
46 or 20?
46, Lordship. 46 of 2015.
In MSC 46,
Of 2015,
you filed review petition.
Lordship.
What was the original award?
Original award, Lordship,
9,80,000.
9,80,625, Lordship.
And thereafter, after review, what has happened?
That review finally, Lordship, review application was partly allowed by the order dated 29/2021.
What was allowed?
The
What relief you sought, got after
Lordship, it
review?
was held that opposite party number 3, 4, and 5, that is the children and the mother of the claimant in MSC case number are not entitled for any compensation, as separately avoided has been apportioned between the claimants and respondent being as legal heirs of the deceased, as they had already filed MSC case number 625 of 15 before MSC Silchar, Lordship.
So why it is partly allowed? Why? No, where is the order of review? So in review, it was brought to the notice of the tribunal that
Lordship.
another case,
Lordship.
in another case, compensation was already
Lordship.
awarded.
Lordship.
Then
But tribunal held that the wife is entitled for the compensation.
twice.
No, for two wives, Lordship, two wives have filed two different cases in two different pieces.
Or for two wives, two different
Lordship.
cases.
For the same person.
625 was filed by
Filed by Lordship Jayarani Roy at Silchar. And 46 of 2015 was filed by Dayabati Roy, claiming themselves as wife of the deceased, Lordship.
so compensation was not awarded to same claimant,
No,
to
Lordship.
different claimants.
Different claimant.
Now, what is your
For the death of same person, Lordship.
maybe if there are more claimants?
No, Lordship, already one case has settled, living at Silchar. She has stated that she is the wife of the deceased, Lordship. And that was also settled in the local Lordship. Now, second case has been filed at Karimgunj.
Okay,
So this is a case of fraud, Lordship, for illegal gain.
by the same insurance company,
Insurance company, Lordship.
by the same insurance.
Lordship.
Two wife has filed two separate MSCT claiming compensation in two different tribunals. Two different tribunals claiming for
Yes.
death of same person.
He has outstead you.
Sir,
Lordship, I'm assisting him.
He was making good submissions.
Okay.
Let him continue. If required, you may help him.
Lordship,
Yes. No, two wives of claimants filed two different compensation.
Lordship. At two different districts, Lordship.
So what is your, but by the same insurance company?
Lordship. One case is already settled in local Adalat.
But insurance, whether insurance company took this plea before the court, that because same insurance company was defending.
No, Lordship, after the judgment, after the award, Lordship, at MSCT case number 46, 2015, then we came to know, Lordship.
That, okay,
Thereafter, we have
therefore you
filed-
filed review application.
Then we filed, Lordship.
Review was,
reject.
review was,
Partly allowed.
how it was partly
They
allowed?
say that the claimant number one, in original case, they are not entitled for compensation. They are party, in both the cases, they were parties.
Claimant number one means?
Claimant number one,
the-
claimant
that-
number one was an earlier MSCT case.
Earlier means, what is the name? Jayarani. Who is not entitled? Jayarani or
Jayarani.
Dayabati?
Order this number.
Now you are preferring an appeal against the order in review,
Which is
No, Lordship.
original order.
that is why
MSC case number 46 of 15. There is one, Lordship, there is a delay of 561 days.
Where have you explained the delay?
Lordship, from paragraph number 5, 6, 7, 8, Lordship.
Main reason for delay is you're preferring a review application
Lordship.
or any other reason.
Review application, Lordship. Because judgment was passed in the year 2018, Lordship. Thereafter, in the year 2019, I filed the review application. And review application was disposed of on 29/2021. Thereafter, Lordship, file was sent to the regional office at Guwahati. And thereafter, Lordship, we have filed the appeal on 18/1/2022.
Heard Mr.
R. Sharma.
R. Sharma, learned counsel for the applicant. None has appeared for the respondent side. It appears from the record that by order dated 1/8/2024, it was held that the notices issued. No. It appears from the record, it appears from the record that the notices to respondent number 2 and 5 were issued in the by substituted service in the newspaper as in pursuant to the directions of this court. And on last date, that is on 1/8/2024, the applicant had filed an affidavit showing compliance of the directions of this court for publication of notice to the respondent number 5, the respondent number 2 and 5 through newspaper in the newspaper. The date of appearance in the notices was 1/8/2024. However, on that day, nobody appeared. Today also, none has appeared for the respondent number 2 and 5. As against other respondents, notices were earlier held to be duly served. This interlocutory application shall therefore be heard ex parte against the respondents. Stop. This application under Section 5 of the Limitation Act, 1963 has been filed by the applicant insurance company, praying for condonation of delay of 561 days in preferring the connected appeal, whereby the applicant has impugned the judgment and award dated 7/9/2018 passed by the Court of Learned District Judge cum member MSCT, Karimganj in MSC case number 46/2015. Learned counsel for the applicant has submitted that after passing of the award in MSC case number 46/2015, it came to the notice of the applicant that in connection with the same accident and for death of the same, it is a death case,
That case, Lordship.
for death of the same deceased, another MSC, another claim case was filed by one
Jayarani Roy, Lordship.
Jayarani Roy, claiming herself to be the wife of the deceased. The said claim case was registered as MSC case number 625/2014 and which was settled in Lok Adalat. Stop. In the Thereafter, another claimant, that is the present respondent number
One lordship.
1, Srimati Dayabati Roy, also claiming herself to be the wife of the deceased late Abhinash Roy, filed another claim case which was registered as MSC case number 46/2015. And by order dated 7/9/2018, an award was a compensation to the tune of rupees 9,80,625 was awarded to the claimant. After coming to know about the filing of another MSC case in respect of the same accident and in relation to the same disease, the present applicant filed a review application before the court in connection with MSC case number 46, before the tribunal in connection with MSC case number 46/2015 on 29/2021. And it is submitted by learned counsel for the applicant that the said review application has been partly allowed. Now the applicant has referred the connected MSC appeal, and it is submitted by learned counsel for the applicant that in pursuing the review application against the impugn order, there has been a delay in referring the connected MSC appeal. Stop. The reasons for delay in preferring the connected MSC appeal has been described in detail in paragraph number 8, in paragraph number 7 and 8 of the condonation of delay application. Stop. Considering the issue involved in this case, as well as considering the reasons shown by the applicant for delay in preferring the connected appeal, this court is of considered opinion that the applicant has sufficiently explained the delay in referring the connected appeal in paragraph number 8 of the condonation of delay application. Stop. Therefore, the delay of
61 days.
61 days in preferring the connected appeal is hereby condoned, and this interlocutory application is accordingly allowed. The registry to register the connected MSC appeal and list it again for admission after a week on a date to be fixed by it.
Deeply obliged, lordship.
May I please your lordship, due to some personal difficulty, my senior K. Gogoi couldn't appear today, lordship, so
Oh,
K. Gogoi, lordship.
okay. So you are
Lordship,
Lordship, kindly,
The council is.
One by one. Let her complete. You wait. I'll give you chance. Yes,
kindly matter may be fixed after 16
you're
of August.
seeking an adjournment.
Lordship.
When?
After 16 of August, Lordship.
Yes, Mr. Rathi, what do you have to say?
Lordship, the matter is in regard to condonation of the delay itself. Lordship, the council is present in the High Court. I was just in the.
Matter without telling us, Lordship. So the matter is come for after mentioning, Lordship. So
This matter?
yes, Lordship, we didn't mention the matter. The respondent
Yes,
has mentioned.
it was mentioned by us, Lordship, the matter.
You are applicant or respondent.
Respondent.
What is the urgency?
Lordship, the matter has been hanging in our head.
Why it is hanging?
Lordship, it is in regard to condonation of delay, and we have got a favorable order.
Any stay is there? There is no stay.
There is no stay, Lordship.
Then what is your status in? You are plaintiff or defendant?
Respondent.
Respondent.
Yes, Lordship.
What was the what for this CRP, this appeal, in whose favor the judgment was passed in the trial court?
In our favor, Lordship.
It was dismissed. Suit was dismissed.
Our claim was allowed, Lordship. In this matter,
There was a counterclaim also. What is the case?
Lordship, we have not received the copy of the IA and the copy of.
No. I am not asking about I am asking about the case what are the facts in the trial court?
Lordship,
Because you are the respondent, you must be knowing.
Lordship, since we have not received the copy of the MFA and the copy of the IA, we are not aware of the claim, the matter. Lordship, we are very much aware that there has been a condonation application has been filed before the court. And Lordship, the condonation matter cannot be entertained, condonation cannot be entertained allowed by the High Court in this matter. Lordship, I would just like to place my objection for the same in regard to the condonation of the matter.
Okay, we'll take it up. There is no such urgency on your part. Why are you opposing their prayer for adjournment?
Lordship, since the railway claims and the railway matters are been filed in bulk, and there has been prolonged litigation taking place in the tribunals and also in the High Court. Because
no, in this case,
Lordship, in this matter, since this appeal is hanging on our head, and because of which we want to get it disposed of, we got it mentioned before the court. Lordship may provide a short date in this matter. It can be disposed of in the very next date of hearing.
Miss, what is your name?
Ellen Sharma.
Lordship, one small submission, Lordship. In another matter, in the case of Brahmaputra Union of India versus Brahmaputra TMT bars, the Lordship, it is in regard to same question of law, and the Lordship has given a date on this matter on 18th of August. So Lordship may be pleased to tie up the matter.
No, this is a matter of condonation.
Yeah. Yes, Lordship.
Okay, I have heard Mr. K. Gogoi was there.
Yes, Lordship.
That there is some statutory bar in Railway Tribunal Act. Some provision was there.
Which does not allow, which bars the
Limitation Act
applicability of
is
Section 5 of limitation.
Section 5. The question is whether Section 5 is applicable to this case or not. Is it the same nature of case?
Same nature, same.
But how can you say you have not yet received the copy of the?
Lordship, it is in regard to the IA has been filed for condonation.
Okay, I have understood. Heard Miss
Ellen Sharma.
Ellen Sharma, London, counsel for the applicant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the applicant, Mr. K. Gogoi. Also heard Mr. D. Rathi, who appears for the respondent. Considering the submissions made by learned counsel for the
respondent,
learned counsel for the parties, the prayer for adjournment is allowed. We are fixing it after 18. On 18th, that case is fixed.
Yes, Lordship. Lordship may tie up the matter in the same,
No, let this case be listed again on 18th of August.
much
Okay.
obliged, Lordship, much obliged.
May it please your lordship. Lordship, this is a statutory appeal. And the appellant Railway have preferred this appeal against the impugned judgment and order dated 2/11/2000.
You are appellant or
And for the respondent, lordship.
where is appellant?
I don't know, lordship. The appellant counsel is not here. It's a very old matter, lordship. It's pending since 2013. Otherwise, lordship, the issue involved in this case is
No,
squarely
in a-
covered with the number of decisions of this court, lordship.
No, but we cannot decide it on merit in absence of the
Correct,
appellant.
lordship. Lordship, one chance may be given and a short date may be fixed because, lordship, it's a very old matter.
None appears for the appellant on call. Heard Miss M.
M. Sharma.
M. Sharma, learned counsel for the respondent. Let this matter be listed again on, when do you want?
Lordship, next Tuesday, lordship, if possible.
On next.
I will inform him.
की तारीख है से?
Next Tuesday will
On
be, lordship,
13.
13.
On 13/8/2024.
Obliged.
Maybe and for the respondent, but counsel for the appellant.
RSA pending since 15. What to do?
Maybe sometime I'm waiting on because everywhere is waterlogging and all. I'm not disputing on that. Maybe
Okay. Then we'll fix it some other day.
my
Fixed date.
kindly maybe fix a date.
None appears for the appellant on call. Heard Mr. M. Ahmed,
That's it.
learned counsel for the respondent. Learned counsel for the respondent. Let this matter be listed. When do you want?
A week or 10 days. That's it. As per law
After-
of convenience.
After 2 weeks on a date to be fixed by registry.
Obliged. That's it. In the meantime, he arrived, my lord. I will again pray for your lordship, my lord. Is it possible? No, my lord. And then after
It
2
may
weeks.
not be possible.
After 2 weeks.
Please, your lordship. Lordship, actually, my senior SK Bolgoturi, he is not well, lordship. He is in AIZ hospital, lordship, Hyderabad. Under treatment, lordship.
Okay. Heard Miss
M. Das, lordship.
M. Das, learned counsel for the appellant who prays for an adjournment on the ground that Mr. S.K. Borkotaki, who is the conducting counsel for the appellant, is indisposed and undergoing treatment at Hyderabad. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks on a date,
Lordship. After.
4 weeks.
After 2 months, lordship.
No, 4 weeks on a date to be fixed. After 5 weeks on a date to be fixed by registry.
Obliged. Please, your lordship. These are two regular first step is my lord will take up at least 16 plus RFA and 919 of 2017. My lord.
Item number 16 first.
16 first.
Item number 16. 16 due. Sixteen.
16. This is RFA, I believe, 119 of 2017. So Nirmala Estates and Services versus Dr. Madhumita Das Majumdar.
You are for the appellant. What is your name?
Megmallar
No, what
Estates,
is your
Enboro.
N Burwa?
The other councils have left the brief.
Yes. What is the matter?
One of the short brief facts of the case are that in this case, the plaintiff, who is a developer company, and the defendant number have sorry, I mean, my lord, this appellant number one is a developer country, and the appellant number two, the director of that company. They have their Megmalla Hillview apartments situated at Jatia Ganeshguri. They were developing this. My lord,
Appellant number one is the company.
company
Appellant number two is the
director of that.
director of that
Their
company.
My lord,
Okay.
The apartments in question are the Megmalla Hillview apartments. At page 4, if my lord comes up to page 11, I would believe this would be page 11. Internal pagination 4, the facts, brief facts, we'll just like to go through that.
Yes.
Beginning, Megmalla Hillview Apartments situated at Jatia Ganeshguri on 18/6/2006. Defendant number 3 informed the plaintiff. Defendant number 3 would be another director of the company. Defendant number 1 company, the Megmalla company, that informed the plaintiff and her husband. Now, my lord, in this case, there are 2 suits filed. One by the present respondent herein, Dr. Madhumita Das Majumdar, which is 185 of 2010.
Madhumita was the plaintiff.
Madhumita Das Majumdar has filed 185 of 2010.
Yes.
And her husband, Dr. Kishore Kumar Das, has filed
Husband name is?
Kishore Kumar Das, who is in the second RFI item 15.
Yes.
Has filed the second title suit 86 of 2010. Issues would be the same, the background events are all basically the same. They are the joint purchasers of a flat. Now, my lord, that
Flat in Megmallar apartment.
Megmallar Hillview Apartments. So that, if I may now turn to page, that page 11, I read from there. So background is that 2 different suits were filed, they were heard together. As they related to the same sort of action.
For what purpose this suit were filed?
For specific performance of the contract, that they had said that they had paid more than the amount which was supposed to be taken as consideration for the flat in question. But thereafter, the appellant had allegedly not executed the sale deed and not transferred over possession of the said flat to them.
Okay.
The gist of the contention of the appellant herein is that there is no, they are still yet to pay rupees 3 lakhs of the agreed consideration. Number 2, there is an allegation that there was a promise made that the ground floor plus the frontage area would be delivered to the plaintiffs as a doctor's clinic. Now, the appellant contends herein that no such promise was made. It was only on the understanding that would help them to obtain any requisite permission. But in any case, the bylaws of the GMDA forbade usage of frontage area for commercial purposes. That is, at that, even now, frontage area is frontage area. It cannot be used for any collateral purposes. So that had to be clear. So that was the stand taken by the basically appellants. I'll come to the other grounds as well.
Okay.
This is the basic contending facts. Now, my lord, The defendant number 3 on 18/6/2006, defendant.
Where are you reading?
The second line of page 11 of the plaint.
Yes.
Page 11, internal page 4. On 18/6/2006, the defendant number 3 informed the plaintiff and her husband that in the said Megmallar Hillview apartments, in which construction was going on in full swing, the defendants can provide a ground floor space measuring 1,000 square foot plus a frontage area of approximately 400 square feet and an area of 1,375 square feet in the first floor. It was further informed that for the ground floor space of 1,000 square feet plus an approximate area of 400 square feet of frontage area, the first floor area of 1,375 square feet along with registration costs, etc. shall come to rupees 33 lakh, provided the plaintiff and husband made advance payment of the said amount. That is crucial, my lord. 33 lakh. It is pertinent to mention here that the amount of rupees 33 lakh was quoted by the defendants for the entire area mentioned hereby, taking the same as a unit, in as much as the plaintiff and her husband at the same time of approaching the defendants had made it very clear that they wanted the aforementioned area for the purpose of obtaining a doctor's chamber cum clinic. So, my lord, the area so far as is concerned is 1,375 square feet on the first floor and 1,000 square feet plus 400 square feet frontage area for purpose of setting up a doctor's clinic on the ground floor, which was the plaintiff's contended. This was supposed to be delivered unto them for.
Oh, was there any agreement?
Well, the agreement, obviously, my lord, the agreement would not mention this.
Or this was understanding?
It is an understanding. That is what the proof. Now, my main issue herein is that the appellants did not file the written statement in the titles. The present appellants did not file any written statement. Appellant number 1 and 2. They were arrayed as defendant number 1 and 2. They did not file a written statement.
Present appellant.
Present appellants herein.
Megmallar and Anup Saikia.
Yes, they did not file any written statement, but they were permitted by an order of the trial court below to cross-examine the plaintiff.
Okay, you
on his
failed to
evidence.
file written statement.
Did not file written statement. The defendant number 3, who was the erstwhile director of the same company, he filed a written statement. He filed his evidence on appeal.
Okay.
But he is not before your attention. So that is the only. These are the only 2 points which I'm taking, because right now I have to rely on the pleadings on here as well as on the evidence, not on my pleadings. I do not have any pleadings. I have only the cross-examination evidence and the pleading filed by the defendant number 3, who was then a director of the company at that point.
Okay.
So, my
Now
lord,
suit was decreed.
suit was decreed. It was decreed. I'll come to that, my lord. This is a decree you will find at, my lord, page 1. Relevant page will be 140. 137. My lord may also know what was decreed, so it will help us in the future. I will read the reliefs portion of the decree at page 137.
Yes.
That the plaintiff is entitled to a decree for specific performance of the registered agreement for sale bearing 870607 dated 6/7/2007, which is exhibit 10 in respect of the suit schedule A flag from the defendants 1 and 2. The defendants number 1 and 2 are liable to execute registered sale deed in favor of the plaintiff in pursuance of agreement for sale bearing so and so dated 6/7/07 exhibit 10 in respect of the suit schedule A flag on any day within next 60 days from today, having received the entire sale consideration amount already from the plaintiff. The defendants are further directed to hand over vacant and peaceful possession of the suit flat to the plaintiff on any day within 60 days from today. Third, that in the event of the failure of defendants 1 and 2 to execute registered sale deed in favor of the plaintiff within the absolute period of 60 days, the same sale deed will be executed and registered by the court in favor of the plaintiff on behalf of defendants 1 and 2 within next 30 days as per provision of Rule 34 or 21. The plaintiff is also entitled to decree for permanent injunction, and defendants, men, agents, servants are hereby restrained from allotting, transferring the suit schedule flat to any person in any manner. So, my lord, the question is now that since the suit was not contested, therefore these decrees were passed on the basis of the pleadings in the plaint as well as of the defendant number 3.
So my lord, I'll first read the pleadings in the plain. Thereafter, the pleadings in defendant number 3 and the respective evidences and the cross-examination, because my point will hinge on the cross-examination. I was only permitted to cross-examine. I cannot traverse any pleading which I have not adduced.
Okay.
My lord, at the next paragraph, the plaintiff and a defendant, the husband, were thereafter taken to defendant number 2 by defendant number 3 in order to finalize the contract. This defendant number 2 is the appellant number 2 here. Defendant number 3 is the erstwhile defendant. At the time of finalizing the contract, defendant number 2 also stated the price of the entire area, included the ground floor space of 1,000 square feet plus area of approximately 400 square feet of frontage area, first floor area of 1375 square feet, which corresponds to a 3-bedroom flat, along with registration costs, etc., have come to rupees 33 lakh. It was, however, mentioned that the permission for construction of the ground floor space of 1,000 square feet though have been applied for but not been received from the GMDA. It was further informed by defendant numbers 2 and 3 that permission was merely a formality, and defendant number assured that 99% chance that permission will be granted. In if by chance the said permission was not granted, defendant numbers 2 and 3 promised the plaintiff and her husband a contiguous 2-bedroom apartment on the first floor, along with 3-bedroom apartment, which booked in the name of the plaintiff, would be allotted to the husband of the plaintiff at the price stipulated in the brochure of the Megaramilla Hairview apartment in respect to a 2-bedroom apartment. So therefore, the plaintiff herein and respondent herein has already booked a 3-bedroom apartment. The allegation is that in case the ground floor is not permitted to be constructed or by the approved, a contiguous 2-bedroom apartment will be allotted in the name of the husband of the plaintiff.
In lieu of the ground floor
Ground floor.
area.
That is the,
Okay.
so that was the basic transaction. It is further stated defendant number 2 and 3 showed the plaintiff husband typical floor plan of the floors of the Megavilla Hairview apartment, where in the said floor plan was shown that each floor there existed 2 3-bedroom apartments contiguous with 2 2-bedroom apartments. Accordingly, on the basis of such representations and assurances given by defendants, the plaintiff and husband readily agreed to the payment of the said amount of 33 lakhs for the entire area, which included the ground floor space of 1,000 square feet plus an area of approximately 400 square feet of frontage area. The first floor area of 1375 square feet, which corresponds to a 3-bedroom flat along with registration costs. The plaintiff deposits the amount of rupees 2 lakh on so and so, then an amount of 2 lakh on 26/6/2006. The amounts were duly acknowledged by defendant number 1. 12/2/2007, another amount of 4 lakh was paid by plaintiff husband, which are also duly acknowledged by defendant number 1. On 22/6/2007, both the plaintiff and her husband were issued respective allotment letters. In the allotment letter issued to plaintiff's husband, it was shown that defendant number 1 had allotted an apartment flat bearing serial number so and so under construction project so and so situated at Palipura. Total cost of the 1,000 square feet was shown at rupees 9,30,000. It was further mentioned in the said allotment letter, the total cost in the allotment letter does not include cost of extra work other than specification laid down, registration, etc. In a similar manner, allotment letter was issued in favor of the plaintiff, where it was shown that apartment flat bearing so and so was allotted to the plaintiff for total cost of 1,350. From the allotment letters, it transpired that the defendant number 1 was charging 2280 for the 1,000 square foot of ground floor space and 3-bedroom apartment measuring 1375 square feet on the first floor. Rest of the amount was charged by the defendant number for the purpose of registration, frontage area of 400 square feet, etc. This is their contention, allotment note, this point. That this is their own calculation, that 2280.33 was the original consideration amount. Now this is they have extrapolated that apparently I am charging 2280 for the ground floor and the first floor. And the rest I'm charging for registration, frontage area, etc. Even though there is not mentioned in agreement that this should be the breakup. This is their, one of the grounds I have taken is that this is their own calculation. On 6/7/2007, 2 registered deed of agreements, deed number 8705 and 8706, were executed by and between the defendant number 1 to the defendant number 2 with the husband of the plaintiff and plaintiff respectively. So in this case, it would be 8706 of 2007. (8706) would be in this present RFA and the title suit. In agreement bearing 8705 of 7, the defendant number 1 covenanted to hand over 1000 square feet on the ground floor under flat number so and so to the husband of plaintiff for a consideration of 9,30,000 as per the terms and conditions. As per the registered agreement bearing so and so, the defendant covenant to hand it over a 3-bedroom flat on the first floor, semi-completed to the plaintiff for consideration of 13,50,000. 3-bedroom flat is more specific, describing Schedule 8 the claim. Now, my lord, the second thing is the question of after that paragraphs are subsequent financial assistance. So, my lord, may skip over that part. Financial assistance which they wanted to take from the State Bank of India. Paragraph 10 would be relevant. Page 60.
Yes.
Even after a year from the date of initial booking by the plaintiff and her husband, the no objection certificate from the concerned authority was yet to be procured by the defendants in respect of 1000 square foot area of the ground floor under flat number so and so of Nirmala Hindi apartment, which was allotted to the husband of the plaintiff. The husband of the plaintiff requested the defendants time and again to obtain the permission at the earliest. It is stated whenever the plaintiff and husband inquired about permission, the defendants and more particularly defendant number 2 gave only assurances that it will be done soon as it is under process. Assurances were further given to the effect by defendant number 2 that if the Guwahati Metropolitan Development Authority does not give the approval to the modified plan, in case the husband of the plaintiff will be allotted a 2-bedroom flat as promised earlier, which is contiguous to the 3-bedroom flat allotted to plaintiff at the rate published by the defendant, i.e. 14,94,200 in lieu of the amount of 930 to 9,30,000, which was to pay for the 1000 square foot ground floor space. Bonafide believing the version of defendant number 2, plaintiff and husband continue to make payments to defendant number 1. Payments so made by the plaintiff and husband were in the following manner. These are the amounts delineated in the table. In total, next paragraph, page 18, after the table. In total, the plaintiff and her husband paid an amount of rupees 30 lakh out of the total consideration of 33 lakh as agreed to. Well, again, this is an admission in the reading itself. Consideration is 33 lakhs. Admitted payment is 30 lakhs. 3 lakhs remain to be paid. For a question of specific performance to even come up, out of this amount of 30 lakhs, the plaintiff paid an amount of 18 lakhs and her husband paid an amount of 12 lakhs. Again, in this breakup, it becomes apparent that 2 deeds of agreement were executed. One is for the first floor flat, even assuming that the present respondent who is entitled to the first floor flat being the allotee therein has to pay 22 lakhs. She has paid 14 lakhs. And she has paid 18 lakhs, sorry, 18 lakhs. Her husband, who is allegedly claiming right and interest over the ground floor part, whether including or excluding the frontage area. He, as per the previous paragraph, is to pay 14,94,200 and he has paid 12 lakhs. Discrepancy here is from their own pleading.
How much he had to pay?
Previous paragraph, my lord, page 10.
14 lakhs?
14,94,200. This is their calculation.
He has paid 12.
He has
And
paid 12.
in the 18 lakhs lot, how much ought to have been paid?
18 lakhs, so you suppose 22 lakhs 80,000 as per their own calculation. I am charging them 22,80,000.
So out of that, 18 was paid. Your submission is that by their own pleadings, they have stated that 3 lakhs is yet to be paid.
Yet to be paid, and even individually, there are amounts yet to be paid. So either their own calculation is off kilter, or they have made misleading statement here. And my lord, for that reason, my lord we remain required to go to the agreement as.
You have annexed it at page.
My lord, this deed of agreement is at 8705 91 to 99. I'll just take my lord through 91, page 91. This is, my lord, the agreement with the plaintiff's husband. If I am, I will read that agreement first because I believe these are standard format agreements. I'll read that and I'll obtain the other agreement. The other agreement is, I believe, there is an IA Civil 4179 that I have annexed separately.
No, which agreement is relevant for this
This
appeal?
case, there is I have made an application for bringing some vital exhibited documents on record which are ordinarily not annexed. This is IA 4179 of 2017.
Putul, IA 4179.
Page 6.
What is this?
This is the deed of agreement that was executed on 6/7/2007 with the plaintiff in the present respondent in the RFA. Here, Lady Dr. Madhumita Das Mazumdar.
Yes.
At page 4, second paragraph,
Page 4 of the,
page 4 of the same IA. I'm internal page 2 of the agreement.
yes,
Yes,
page
in the
9.
third paragraph, where the amount is given. And whereas the second party purchaser agreed to purchase an ownership flat at having 1375 square feet on the first floor, building number flat number 101A1 in the complex described above, consideration of 552,500 against cost of floor roof 136,500 against proper share of land over the so and so square feet building area of the building would be 611,000 against construction charges, including raw materials and 50,000 against parking in the ground floor in total to be 13,50,000. Here the deed agreement mentions 13,50,000 for the first floor. For the first floor,
But she has paid 18 lakhs.
he has paid 18 lakhs. Her calculation most probably would include the ground floor as well as the first floor. My lord may make a note of that. This is because this is admitted document. There is no controversy.
Where is the amount mentioned in which para?
This is the third paragraph.
6,11,000,
11,000 again.
13,50,000.
1350.
Yes.
Now, my lord, this is the amount. Now, my lord, we come to the next page, the terms and conditions. Paragraph 1. The intending allotee applied for allotment of an apartment with full knowledge and subject to all the laws, notifications, and rules applicable to this area in general and group housing project in particular, which have been explained by the company, understood by him or them. The intending allotee has satisfied themselves, herself, himself about the interest title of the company and land which the said apartment is constructed and has understood limitations, obligations in respect thereof. Intending allotee agrees that there will not be any further investigations, objections by him or them in this respect. Intending allotee has seen except plans, design specifications set out in the brochure, agrees the company may make such variations, alterations, and modifications therein as it may in sole discretion deem fit and proper, or as may be done by any competent authority. And the intending allotee hereby gives his or their consent to such variations, additions, alterations, and modifications. Intending allotee has also seen the specification information as to material to be used in the construction of building flat, which also tentative company may make such variations and modifications therein as it may in its sole discretion. Subsequent facts are that since the flat was intended for the purpose to be used in subsequent facts are that since the flat was for refund the amount deposits in interest at the rate of 10% per annum.
What was the liability? Refund
The amount deposited.
with an interest of 10%. This was your liability as such.
And pursuant to an order of this honorable court, we have already deposited 6 lakhs prior to the admission of this appeal.
They have deposited 30 lakhs.
They have deposited 30 lakhs.
30.
30 lakhs. They have deposited 30 lakhs for
Two ground floor as well as for first floor.
As well as the first floor.
The present defendant, respondent number 1,
Yes.
has
Has-
deposited 22 lakhs,
18
18 lakhs
lakhs.
for first floor flat.
First floor.
Okay. Okay.
Then my lord may come to
No,
Okay.
this clause 4 of the terms and conditions. Under what circumstances the question of refund will arise?
refund will arise. My lord, that is what I am coming to another clause which will answer your lordship's question. Page 8, clause 19.
Clause
19, page 8. The intending allotee agrees that if as a result of any legislation, order or rule, the company after allotment is unable to deliver possession to the intending allotee, the only responsibility and liability of the company will be to pay to the intending allotee the amount attributed to the said apartment that may have been received by the company at the time, without any interest or compensation of whatever nature and in a manner as may be decided by the company and save it as aforesaid. Neither party shall have a right or claim against the order in relation to this agreement. So this is a second tangent whereby if there is a change in law, then the amount deposited has to be refunded back without any interest or compensation thereon. This clause would be applicable in respect of the husband of the present name. He desired, he paid amount for 1,000 square feet plus frontage area. The law renders the frontage area permission inadmissible. On that point, husband of the plaintiff says that I'm a doctor, I need the frontage area for my clinic. The 1,000 square foot ground area is of no use for me. His contention is that. So therefore, the only relief that he could have made is a return of the money deposited by him in respect of the ground floor area, flat, without any interest or compensation in respect of clause 9. That is for the other husband of the plaintiff. I'm talking
In
about. These
others-
are two separate cases because
Okay.
one is the ground floor, one
No,
is the.
both the suits were defended by defendant number 3, who is one of the director.
He was one of the directors at that point.
Whether he took plea that there is a bar, legal bar in his written statement.
That is what, Melon, I will come to.
We will come to that later on. You go by your flow. Just my query, whether he took that plea in his written statement or not.
That there is a bar to claim of interest and comp.
No, that there is a legal bar in JMDA rules that frontage area cannot be.
No, I will have to just check. I have taken the ground in the appeal that we have taken that ground, but that was not adjudicated by the.
No, but your taking ground does not arise because you have not filed any written statement.
Right.
In cross-examination, whether you have put this question to any of the.
Well, that is what the cross-examination, I will come to the evidence and the cross-examination, as well as the evidence of the defendant number 3. My lord, may kindly give me some time, because I believe this has not been annexed, the written statement of the defendant number 3. Yes, at paragraph 1 of the, I'm reading, I'll be handing over a copy, this certified copy of this. To the bylaw of the GMDA specifically stipulates that parking spaces are not allowed to be converted for any other purposes. The front area.
This was the question. What is this?
This is the written statement of the defendant number 3.
Okay.
That plea has been taken. So the,
Any issue was framed?
no issue was framed on that.
Okay.
I will also, my lord, if in detail, if that point has been taken, I will just go through that different. Question mentioned. That the point of the GMD has not been elaborated upon other than that single line. I may be permitted to present a certified copy of the written statement for lordship's perusal only, because I'll be relying only on the cross examination in case your lordship requires for reference. Now I look to now let me come back to page 19 in the plaint
19 of the.
plaint.
So in the IA, you have taken me to the agreement between wife Madhumita and the appellant, where clause 4 says that for if the appellant is unable to hand over the possession due to reasons mentioned therein, then entire amount would be refunded along with an interest of 10% per annum.
Yes.
And clause 19 says that in case of difficulty of handing over the possession due to any statutory bar of legislation and change of rules, then entire amount will be refunded without any interests.
So, my lord, and there is another point as well. Clause 13, my lord, may come to cost.
No, now why are you referring to these clauses?
Yeah.
No, what is the submission?
In regard to these clauses,
Yes,
my lord, that there is an particular amount which they are claiming a relief for specific performance. Am I saying that the only relief that they are entitled to under this agreement, in case the ground floor did not meet their specific interest or their desire, was for the refund of the amount deposited by the allotee, intending allotee. And in case the first floor did not meet, their problem is that they have clubbed together the entire causes of action. That is another problem which I have faced. That there are two intending allottees. One is an intending allotee in the first floor, one is an intending allotee in the ground floor.
ground floor.
But being husband
This
and wife,
appeal pertains to first floor.
first floor.
Okay,
But being husband and wife, being members of the same profession, they have endeavored to create an impression that the entire thing was conveyed as a lump sum agreement arrangement, whereas there is no lump sum arrangement of any kind. There is no overall agreement specifying 30 lakhs or 33 lakhs or more or less for the entire setup. It is only for the sake of convenience that the appellant assured that we would try to make all necessary.
the relief which was granted in this suit
Yes.
was to execute a deed of sale
In respect of that agreement.
in respect of
870.
first floor,
First.
first floor.
First. So, my lord, that they have endeavored to create an impression that there is a lump sum consideration amount payable. There is a lump sum, the entire only both the first floor and the ground floor has to be handed over with frontage area
Okay,
because of the implicit and on the basis of an implicit understanding between the parties. That my lord, that is the point I'm taking, that if in case that impression is sought to be conveyed as an argument, thereupon the plaintiff, the other plaintiff, the husband of plaintiff became a necessary party in the first suit and vice versa. Two suits need not have been filed. The very fact that two suits were filed,
no, but there were two separate agreements
two separate agreements,
with two different allottees.
allottees,
They happen to be husband and wife,
they happen to be husband and wife.
and relief was granted in respect of the separately.
Separate.
So where is the problem?
So relief was granted, but I'm saying that amount that was granted, that the relief was granted, we're saying that we cannot transfer the flat. So if I'm unable to transfer the flat because they have desired that entire flat, the first floor and the ground floor. If not the ground floor with the frontage area, then I desire the contiguous 2-bedroom flat. But in this case, what would logically would have been followed would be the first floor and the ground floor 1,000 square feet. That was the offering we made, that take on an as-is basis, take the first floor, take the ground floor 1,000 square feet by the husband of the
Without frontal area.
without the frontage area. Thereupon their counter argument was that what would I do with
What court directed?
the court did not direct anything about giving the frontage area.
No, what in respect? The sale deed would be in respect of which area? In
In
respect,
respect of the agreement.
area mentioned in the agreement. Now, in agreement, whether frontal area was mentioned,
8705, there is problem. Schedule is that. With 705. 1,000 square foot open space on the ground floor. Under flat number 101, that is at page 74 of the other RA.
no, you take one by one.
But this is 8705, that would be in respect of the husband of the plaintiff, the ground floor space.
That's because there are two separate RFAs.
Yes, yes,
And you have to make submission separately.
separately. My lord my lord may kindly grant me some time because I have to now collate those two together. I'll be jumping between two RFAs. If I can make a collated submission, argument kind of a submission that will facilitate your lordship as well.
Not today.
No, not today because I have also a matter before amicus curiae brief.
Then you should have made submission in the beginning itself. Okay, because matter is complicated unless you present it in a proper way.
Yes, sir.
You have to make presentation, make your submissions with regard to separate RFAs separately, forgetting that they were husband and wife.
Yes.
Because reliefs were granted separately. Separate decrees were passed in respect of separate agreements. So if you, now I have understood that they were husband and wife, so some overlapping may be there. But it may happen that one appeal may be allowed and another may not be allowed. Therefore, you have to make submissions separately. Yes, what is to be done?
Fix a date next week.
Like 2 weeks if possible. These are both voluminous.
So then
Like-
everything will go, though I have taken notes.
My lord,
Okay,
my lord, when my lord is sitting, I have no objection. Next date on when my lord is sitting.
Not item number 15 and 16, my lord already heard at length. So my lord, both the matter will be marked as a part heard, my lord.
One of the last matter which my lord was considering, item 16, my lord has passed an order. Item 15 is also related matter.
No, 15 I have not heard.
Understand, my lord, because he is relying on the agreement between the husband, wife, as well as the builders.
But the appellant's counsel needs 2 weeks' time.
I understand.
Then I am not certain that this roster will continue.
And that is also true.
So if I keep it part heard, it will be difficult. If rosters continues, then it will automatically come to me.
Item number 16, my lord has already heard it. Therefore, just a prayer, my lord, if at all possible.
No, you may make, let us see when it is listed. You may make mention
Very well, my lord.
that it was heard by me, so I may take it up whenever it is listed. There are 2 courts. It will be listed in one of the courts. So you may make mention whenever it is listed.
Very well, madam.
Okay.
Keep it.
My lord, senior counsel is on like in another room. Matter may kindly consider for a time.
Lordship, can it be taken on Tuesday?
Today is Tuesday.
Next Tuesday, 13th.
13, we have fixed many matters. This is CRP, na?
Yes, yes, my lord.
Who is appearing for the petitioner
GM Sahavala, sir. Senior advocate.
and for respondent?
SP Royce.
Okay. When do you want?
Lordship, next week, meeting.
Next. Third, Thursday. Next Thursday.
Lordship.
Learned third, Miss M.
Yeah, sure.
K. Sharma, learned counsel for the petitioner, as well as Miss
V. Rai.
V. Rai, learned counsel for the respondent. Learned counsel for the petitioner has submitted that the conducting counsel, senior counsel, Mr. G. N. Sahavala, is on legs in a different court. And on that ground, praise an adjournment for today. The counsel for the respondent side does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed again on 20 August. Because in the next Thursday is 15th August. 22 August. 22 August.
Oblige.
May it please your lordship. Lordship, for the sake of understanding of the facts and circumstances of the cases,
Are both of you are ready, or you will leave halfway?
Lordship, I am appearing in all the 4 cases, Lordship. I'm ready.
You are
But
ready or
claimant
not?
side is not there. One of the side is not there.
These are MEC appeals.
MEC appeals.
yes, your lord. There are 4 appeals arising out of the same.
Who is not there?
Claimants.
Otherwise, who is appearing for claimants?
We police person.
They were contesting this appeal.
Yes. We were present on the last occasion.
No, this is part heard.
Sparta.
Part heard with
Oh,
a
it-
different judge.
Your lordship, I did not see the court case
it-
that it was part.
Lordship, it was heard by Justice
PJ Saikya.
PJ Saikya.
So it will go to that
But
court.
I
only.
thought that he has not kept it part heard, so I
No, it
didn't
is
know.
part heard. That is the problem with part heard. Now, unless it is released from part heard, it may not.
Their part was complete there and my was too.
Yes, so it will go before that bench. Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for respondent number.
Lordship, I am appearing for respondent number. What?
Respondent.
Not all the respondents, Lordship. I am appearing for the owner.
Respondent 3.
3 in 2 appeals, Lordship, and 2 I have filed.
In respondent number 3 in MSc appeal number
MEC appeal number 3 and 4.
3 and 4.
Yes, and the other 2, Lordship, 38 and 40, that there I am appealing, Lordship.
Also heard. So, on perusal of the order dated 28/6/2024, it appears that this matter were heard by a coordinate bench of this court and was kept as part heard. Therefore, the registry is directed to list these appeals before the appropriate bench.
After 2 weeks. Okay, registry will fix it.
Registry will decide.
Much. In this case, Lordship, I was told that the appellant will be a bit late. So matter password for the time being, Lordship.
On last occasion also, nobody appeared for
Yes,
this.
yes, Lordship. But today morning, just now also she is calling me. He's in here.
Okay,
May I take up the call if they want adjournment, then I will.
okay.
Yes, make this as a lordship. Now, this appeal, in this appeal, we have challenged the order dated 11/2/2021, passed by the present appellant, whereby, my lord, the prayer for decree of divorce was rejected, my lord.
You are husband.
I am husband, my lord.
Okay.
Despite there being overwhelming materials of mental cruelty, my lord, although it was founded, the learned trial court has found, my lord, that there are mental cruelty. although my lord, he declined to allow the prayer, my lord. So we are before this honorable court, my lord. Now, in this case, my lord, the present appealant and the respondent, my lord, the marriage took place, my lord, on 11/10/2024.
Question number 7.
Yes, issue number 7.
Question number 7 is whether the defendant one acquired his right title by adverse position.
But my lord, this is not the issue in this substantial question of law regarding adverse possession. This,
Now, what you want to say?
My lord, even Lawson Kali say my issue memo of appeals. I raised this point.
No. In this appeal, we will be confined only to the substantial question.
Yes. But
3 substantial questions of
Question of
law.
law.
were filed.
But if you also kindly see page 3 of my appeal. B, round B, second question of B.
Yes.
But that issue has not been framed. Although I make a prayer before this noble court. Because otherwise both the court will has
No, then
taken up those issue. Both the court will have decided the said issue or regarding whether adverse position. Now it is up to lordship or
whether he has acquired right
Yes,
title,
sir.
whether the plaintiff suit is barred by limitation by defendant number 1 and 2 acquiring possessory right, their question of facts are involved,
yes. and
which
it-
was
the-
dealt with by the trial
court
court
and
and
the
the first appellate.
even the trial court and appellate court has come to a finding in that earlier suit in examination in chief. This appellant have stated that this landowner had allowed him to stay. So being a permissive occupier, they cannot claim
A
adverse
finding is there.
Yes, finding is there.
So how it can be a
These are facts,
substantial
my lord. These,
question of fact is involved.
yes. That your lordship will find at page 18.
But issue number 7 discussed by the appellate court will also page 18.
18.
Page 18. Issue number 2. Issue number 7. 22. Adverse positions.
This is a question
Question is
which
also
can be raised before first appellate court
Appellate court, yes.
only. The nature of this nature of question may be raised before first appellate court,
Yes.
which can go into the question of facts,
Facts.
which you have raised, and the first appellate court has decided it.
Yes, ma'am.
Now this court cannot go into
Go into
that
that.
issue again. This court will be confined only to the substantial question of law.
In this regard, my lord, you listen, just I submit because otherwise, because it is also one of such a question of law.
Okay,
Is to
this
be
I,
fair. If your lordship not consider it, I have not pressurized, but some
mentioned-
finding is to be given on this point, my lord.
okay.
Whether it is a substantial question of law or not. In my submission, my lord, it is a substantial question of law because adverse position is a very important question, my lord. Whether I have acquired advisory right or not. And both the court will although rejected my claim, issue no decided the issue number 7 against me. However, it is a substantial is to be decided. Number two, my lord, now I have no any more time because now already it was already held. I have also
Let me dictate it.
and
Let me dictate this point. Your submission is that this
But this regarding my lord, adverse position, my lord, this is a finding of fact. And two courts below, my lord, concurrently have decided the issue. Now, this court being a my lord in a second appeal, whether my lord, the second appeal, the facts can be appreciated.
Mr. J. Ahmed, learned counsel for the appellant, also submitted that though in the memo of appeal, the appellant had stated following substantial question of law, same was not formulated by this court at the time of hearing under Order 41, Rule 11 of the CPC, namely, within inverted comma, whether the suit filed by the plaintiff is barred by limitation and the defendant number 1 and 2 have acquired possessory right, title and interest over the suit land by way of adverse possession on them. Therefore, the learned counsel for the appellant submits that as this court has power to formulate substantial question of law, even
103. Section 103.
even later on, if it is satisfied that case involves such a substantial question of law. Hence, he submits, hence he prays for framing the above mentioned, prays for formulating the above mentioned substantial question of law in this case. On the other hand, Mr. A. Das, learned counsel for the respondent has submitted that the question proposed by the appellant, the above mentioned question proposed by the appellant involves questions of fact, and on the said issue, on the said question, issue number 7 was framed by the learned trial court, which was
As well as appellate.
as well as appellate court, and both the court gave concurrent finding that the appellant, that the suit is not barred by limitation and appellant acquired no right, title and interest over the suit land by way of adverse possession. Learned counsel for the appellant, learned counsel for the respondent has also submitted that in the where the permissive possession.
No, I am not his permissive position, my lord.
Yes,
No.
para, my lord,
His submission.
in this type, page 18, Lord, you will kindly turn to page 18 of the memo of appeal. In title suit that 66, he has admitted.
Page?
Page 18, my lord, this page 18 memo of appeal, last part, para 23. Page 18, 1-8. That you got it, my lord? In title suit 6694, the issue number 3 was as to whether the defendant number 1, present appellant, has been possessing the suit land since 3/5/71 adversely and acquired right title interest over the land in that suit. Defendant number 1, present appellant, filed his evidence on affidavit as DW2. In his written deposition, he has stated that he and his predecessor has been possessing the suit land for last 70-80 years by constructing dwelling houses. During cross-examination, DW2 has stated that his father has taken the suit land on lease from the father of DW6, Biren Count, who is my vendor, my lord. And so-and-so count late so-and-so at the yearly rent of ₹3. His sister so-and-so brought him to the suit land to look after her as she had no children. Prior to coming to the suit land, she was residing at Rajamoidam along with his family. He has been residing over the suit land for the last 30 years. The learned trial court held defendant number 1 has categorically admitted that his father was a lessee under the original owner of the suit land at an yearly rent of ₹3. It is therefore an admitted fact that the defendant number 1, by stepping into the shoes of his father, has also acquired status of a lessee in respect of the suit land. Hence, the defendant appellant is a permissive occupier over the suit land under the original owner of the land on payment of rent. The learned trial court also held that it is an established principle of law that a permissive possessor cannot set up a plea of adverse possession. Thus, the issue was decided in negative as against the defendant number 1.
Now, question of lease. Lease is there. I have taken the lease from the father of the vendor.
Yes, very
The-
permissive.
the
Yes.
Learned counsel for the respondent has also submitted that in
Para 23 of the appellate court judgment.
the para 23 of the first appellate court, judgment of the first appellate court in title appeal number 5 of 2011. It was the first appellate court gave a concurring view regarding the finding of the trial court to the effect that the predecessor in interest of the present appellant were permissive possessor over the suit land, and therefore the question of adverse possession does not arise. Stop. Considering the submissions made by learned counsel for both the sides, this court is of view that the the substantial question of law, additional substantial question of law, which the learned counsel for appellant is proposing at this stage involves questions of fact also involves question of fact, which was already dealt with by the trial court as well as first appellate court in this case. And this at this and in this second appeal before the third forum in this litigation, this court is of considered opinion that the said question said question would again involve appreciation of facts, would involve appreciation of facts again. And hence, this court is of considered opinion that the above mentioned question proposed by the appellant is not a substantial question of law involved in this case. Hence, it is not required to be, hence an additional substantial question of law is not required to be formulated at this stage.
Well, on that point, I want to, there's a citation, my lord. 2006. This is not there, it is not there, my lord.
This
2006.
additional question of
Yes, because your lordship only had concurring finding. But here, the in judgment on 2006 1 SCC 168. 2006 1 SCC 168. And the Civil Code section 100 second appeal, concurrent findings of fact, interferences with, when permissible, lower courts having concurrently erred in not appreciating oral and documented evidence properly held, High Court was at liberty to reappreciate the evidence on record in its own conclusion, revising the order passed by the lower court. So this court can do it because both the court below have not appreciate the evidence on record properly, my lord. As I found in many others cases, they said there is a counterclaim. Now record reveals that there is no counterclaim. So such omission
that
is
is
there.
not you have not raised that question of perversity that
The perversity is also there. I also raised a question of perversity. I also raised that point also. In my appeal, I also take this point also.
My lord,
Okay, make your
the-
submission.
The appellant may take, my lord, hundreds of grounds. Now, while framing
is
the
for the
substantive.
court.
No, that is why for the
Yes.
court. That is why
It is for the
just
court.
That is why
yes, my
the
lord.
court, after hearing
Yes,
the
yes, yes.
parties, has framed.
No, I am not
the
disputed
question
it, my lord.
So at that time, while framing the question, it was not framed. That means the court had considered it as and rejected it, madam.
Yes.
Now, during the course of hearing, if the court finds,
And
my lord,
Each paragraph,
then one,
separate.
now one,
Add no.
No, my lord,
No,
10100
103, my lord, says if
104
the
says.
evidence is not appreciated. Now,
My lord.
as regards adverse possession, what evidence he has adduced, my lord?
My lord,
Being
10100
a
section
second
4, my
lordship
lord.
will whether
Section
again
4,
appreciate the evidence. my
where
lord?
the High Court is satisfied that a substantive question of law is involved in any case, it shall formulate that question.
Accordingly,
Also.
the three questions were formulated.
Yes,
It means that no other question was left.
yes,
High Court has a power
yes.
in the proviso
Yes.
that if it fails to, that High Court
Yes.
is not barred from formulating an
Framing-
edit.
Any
During
question
the
of law.
course of hearing, court finds that yes, some points are necessary, court can frame it. But my lord, there is a rider. It says that if the evidence are this 103, my lord, it's
What is the writer?
my lord, it says that if the 103, because I'll just read out, my lord. In a second appeal, the High Court may, if the evidence on record is sufficient. So then, my lord, the evidence on record has to be sufficient. If he says that this adverse possession, now what evidence he has led regarding adverse possession? Apart from making a simple and bold statement in the written statement that he has been occupying their land for so many years, so he has perfected title. Apart from these statements, whether he has adduced any evidence, what type of evidence?
No,
he has adduced?
my evidence is part is there.
That
Record is
right.
there, my
So
lord.
if-
I
if
have given
evidence on
evidence.
record is sufficient, my lord.
Yes,
then
I have given,
Yes.
I have given the evidence, my lord. As my evidence has been recorded, I clearly stated that I am continuously, openly, my lord, possessing the sweet land. I clearly stated in my evidence that even when that health was executed, I was in positions. Even after execution of the Ellis held it, my lord, I am also continuous position. Thereafter, they filed a suit, my lord.
That is why there being a concurrent finding, the High Court, while framing the substantial question of law, felt that these matters, question of fact has already been decided by the two courts. So that was, it was not, my lord, considered.
Now you will also kindly see in regarding that point, non-substituting the legal heirs of the assessment number 2, defendant number 2, my lord. Now it will kindly see 219 11 SCC 7 is I possible, my lord. Let's see. 2019 11 SCC 787. Can I read the heading, my lord? That's first time I read heading. Civil Procedure Code 908, Order 22 Rule 4. Omission to implead ALRs of some of the several respondents who died during the pendency of appeals, whether interest of only deceased respondent would abate, and appeal would continue as against the remaining respondents, or it wholly abate entirely. Test. If allowing appeal against remaining respondent would result in two conflicting degrees in same suit with respect to the same subject matter, appeal would abate as a whole. In our case, my lord, in suit also not, they need not take any steps for to bring on record the respondent number, defendant number 2.
What it means? Two conflicting decrees.
Yes. Relevant paragraph here mentioned here.
In this case, there is not two conflicting decrees.
My lord.
How this observation is applicable to your
Because
case?
here, in also can I reading the paragraph. That is just I am reading the paragraph, my lord. Paragraph 12, 13, my lord. 14.
Yes.
If they file it, then it is okay. Then paragraph 12 first. Although it is somewhere against me, but paragraph 13 clear it. Order 22 rule for CBC lays down that where within the type limited by law, no application is made to impede the legal representatives of a deceased defendant, that suit shall abate as against the deceased defendant. This rule does not provide that by the omission to impede the legal representative of a defendant, the suit will abate as a whole. If the interest of the co-defendants are separate, as in the case of owners, the suit will abate only as regards to the particular interest of the deceased party. In such a situation, the question of the abatement of appeal in its entirety that has arisen in this case depends upon general principles. If the case is of such a nature that the absence of the legal representatives of the deceased respondent prevent the court from hearing the appeal as against the other respondents, then the appeal abates in 2-2. Now, paragraph 13, my lord. In the matter on hand.
No, you read
yes,
entire paragraph.
Yes, the abatement takes place only in respect of the interest of the respondent who has died. The test often adopted in such cases is whether in the event of the appeal being allowed as against the remaining respondents, there would or would not be two contradictory degrees in the same suit with respect to
How this portion is applicable? How there will be two contradictory decrees?
Because it is appeal. That order pass on appeal. Our case is in suit. In suit, that defendant number was during the pendency of the suit, defendant number to expire. Their legal representatives were not bring on records, although those survives. But whether if degree can be passed against this, whether I have a right title interest, it will be decided by the court. But in the suit, right title of interest of the defendant number 2 could not be decided, cannot be decided against the he already has that he has not get a chance to contest the suit. His legal is not again, not get a chance, he could not lead the evidence. Maybe their contestation is different, my lord. There should be
Then
given
it will abet
opportunity.
against that defendant.
Yes, the defendant.
Then any legal heirs of that defendant may
Yes. in
raise
act-
objection
objection
later on,
In the
but
execution
not
case.
against you. Because
None against suit. It is not against me, my lord. It will be against suit, my lord. It is, suit is to be decided. Suppose a lawsuit passes judgment, already man is died. How can judgment
No.
decree can be passed?
no, that is my question.
Yes.
When there are two defendants
Yes, yes, yes.
and their interests are separable,
Ah.
then suppose one defendant dies
Ah.
and other defendant is still possessing my land, claiming
Now, both the
him-
defendant position, both the defendant
other
position.
defendant died.
That, but legal, they are possessing their.
Then,
Aside from you are saying they are possessing.
Then against
Eh,
them,
It will not be
it will not
executed.
abet, but against you it will abet because
Yes, yes, yes. I am placing that judgment also because there will be conflicting. Suppose they are going to execution for the degree. How can they execute the degree against the dead persons, against defendant number 2?
they will execute against you.
Then it should be clear. Then I will come later on. Paragraph 13 also. It will be clear by lawsuits. I will thankful for that. Paragraph 13. In the matter on hand, the absence of certain defendants who have been deleted from the area of the parties, along with the absence of legal representatives of a number of deceased defendants, will prevent the court from hearing the appeals as against the other defendant. We say, so because in the event of these appeals being allowed as against the remaining defendant, there would be two contradictory degrees in the same suit in respect of same subject matter. One degree would be in favor of the defendants who are deleted or dead and whose legal representatives have not been brought on record, while the other degree would be against the defendant who are still on record in respect of the same subject matter. The subject matter in the suit is the validity of two wills. The courts, including the division bench of the High Court, have consistently held that two wills are proved, and thus Viraswamy, being the beneficiary under the two wills, had become the absolute owner of the suit properties in question. Such degree has attained finality in favor of the defendants who are either deleted or dead, and whose legal representatives have not been brought on record. In case this appeal are allowed, in a other defendant, the decree so passed by this court in this appeal would definitely conflict with the degree already passed in favor of the other defendant. As mentioned, Supra, court cannot call upon the to make two inconsistent degree about the same subject matter. In order to avoid conflicting decrees, the court has no alternative but to dismiss the appeal in their entirety. Now, another next, my lord, 2010, 11 SCC.
Yes.
Here, my lord, only question is, my lord, the already the in suit has a decree in favor of the plaintiff. But yes, it is decree. I lost the suit in the board of Ram. But defendant number 2 cannot get any chance to make his case. That is why I am placing this judgment, my lord. That is on 2010, 11 SCC.
476.
Which para you are relying?
Yes, there are 17, my lord. 17 to 8, 7 to 70 to 20. 17, my lord. Therefore, the law on the issue stands crystallized to the effect that as to whether non-substitution of LR of the respondent defendants would abate the appeal into two or only qua that this is respondent dependent depends upon the facts and circumstances of an individual case, where each one of the parties has an independent and distinct right of his own, not independent upon one or the other, nor the parties have conflicting interests, interse. The appeal,
Which para you are reading?
paragraph 17.
17, yes, yes. It is important. Yes,
Again, I read my last.
yes.
Therefore, the law on the issue stands crystallized to the effect that as to whether non-substitution of LR of the respondent defendants would abate the appeal in toto or only qua the deceased respondent.
Yes, yes.
Qua respondent defendant depends upon the facts and circumstances of an individual case, where each one of the parties has an independent and distinct right of his own, not independent upon one or the other, nor the parties have conflicting interests, interse. The appeal may abate only qua the deceased respondent. However, in case there is a possibility that the court may pass a decree contradictory to the decree in favor of the deceased party, the appeal would abate in toto, for the simple reason that the appeal is a continuity of suit, and the law does not permit two contradictory decree on the same subject matter in the same suit. Thus, whether judgment decree passed in the proceeding vice versa, remaining parties would suffer the vice of being a contradictory or inconsistent decree is the relevant test. Now, 18. The instant case requires to be examined in view of the aforesaid settled legal provisions. Every owner has a right to possess and enjoyment of each and every part of the property equal to that of other owners. Therefore, in theory, every owner has an interest in every infinitesimal portion of the subject matter. Each has a right, irrespective of the quantity of its interest, to be in possession of every part and parcel of the property jointly with others. A co-owner of a property owns every part of the composite property along with others, and he cannot be held to be a fractional owner of the property unless partition takes place. In this case, partition is also not there. Now, 19. In the instant case, a declarative decree was passed in favor of the respondent plaintiff, and similarly, Pareto to the effect that they were co-owners. Now, they had specific shares but were held entitled to be in joint possession. The applicants had sought relief against Somiti so before the first appellate court, as there is a decree in her favor passed by the trial court, where Srimati Parasoto has been implemented by the applicants as pro forma defendant. In such a fact situation, she had a right to contest the appeal. Once a decree had been passed in her favor, a right had vested in her favor. On her death on Swensu, the said vested right developed upon her heirs. Thus, appeal against Srimati Swensu stood abated. In the instant case, the first appellate court rejected the application for condemnation of delay, as well as the substitution of LRs of Swensu, the sum of hearing. The only question remains as to whether the appeal is abated in toto or only in respect of the share of Swensu. The High Court has rightly reached the conclusion that there is a possibility of the appellate court to revise the judgment of the trial court, and in such eventuality, there could have been two contradictory decrees, one in favor of Swensu and others in favor of the present appellants. The view taken by the High Court is in consonance with the law laid down by the court essentially. The facts of the case do not warrant any further examination of the matter. So, my lord, I may be I may have a right or not. I may be a trespasser, maybe, but it is the duty of the plaintiff to bring on record to show that they can make relate evidence, whatever they want, my lord. But that has not been done. Now, my lord. Now, one case I am found, my lord. Although the defendant, one defendant has expired, but they did not file any petition for substitution.
No, one query.
My lord.
Whether this issue number 2, whether the suit of the plaintiff had abated in view of abatement of suit against the defendant number 2, whether this plea was taken before the first appellate court.
Yes. Yeah.
It was taken.
That issue was also framed there.
What was decided?
Oh, mental,
Which issue? First appellate court.
here also the issue number. So it is by the limitation.
This was not in.
Not discussed now. I don't think.
Appellate court. But my appeal to the there.
At page 12, my lord, the issues. Whether the plaintiff has any cause of action for the suit, whether the suit is barred by limitation, whether the suit is.
No, that issues are framed by trial court.
And the appellate court had also decided these issues on.
Okay.
Because.
So before appellate court, this ground was taken or not?
Yes.
That's.
Tell us kindly see, in my appeal, memo of appeal, I have taken the ground. In my memo of appeal, paragraph 3.
Page
81.
No.
81.
No.
Being highly agreed.
Thank you.
Page 81.
Para?
There are two.
3. It starts from 3, man. For that.
Paragraph 3. For that, let brain count defendant number 6 execute all cell deed and the deeds of the activation. He is the prime player in this episode. Brain count died during the pendency of the suit, and his hairs were not substituted. Similarly, Similarly, respondent number 2, Alauddin Hakim, who are the defendant number 2 so and so, contested the suit and filed written statement. He too died during pendency of the suit, but his hairs were not substituted. Therefore, respondent number 2 and 9 are necessary parties, and in their absence, no effective decree can be passed. As the learned Munshi passed the judgment so and so, it has become a judgment against 2 dead persons, which is void as per law. Curiously enough, the respondent to Kelly Barley kept himself out of the purview of this court, but his game might be exposed.
So now
that fellow has been taken.
He inducted respondent number 2, who died because no one counts. Now he himself is raising question upon him. Curiously enough, the respondent number 2 cleverly kept himself out of the purview of this court, but this game might be exposed.
Cleverly, my lord. They cleverly outed.
No.
They are not clever. They cleverly, they are not.
Curiously enough, the respondent number 2 cleverly kept himself out.
Yes.
Who is to this Alauddin Hakim?
Yes.
He himself.
They done it. They are not in cleverly. They are not substitute the legal
He-
heirs, it is meaning
he is your
in that
person.
way. Now, let me complete. Now, my lord, you'll also kindly see the whether the rational number 6, the original owner who alienated the sale deed, he is the necessary party or not. But he is to be proved the case that I alienated the sale deed, I have not alienated. He is the persons. He should have, their legal evidence should have made parties. But that issue is not from here. Rational number 6.
Because that issue has already been decided in that 66.
Now,
my lord, the earlier.
you will also
which
kindly
is a
see
part of this case.
in judgment, I get one fact that in one suite, the one defendant's expert, then during the pendency of the trial, but they did not file a petition within the time before pronouncement of the judgment. Subsequently, they file a petition after pronouncement of the judgment. They file a petition under Order 22 Rule 4 to bring on those that plea has been rejected. That plea has been rejected. In present case, they are not even take such steps after pronouncement of judgment also.
No, the issue is
Now, number 1, I am confined in regarding restaurant number 2, dependent, not others.
whether the suit of the plaintiff had abated in view of the abatement of suit against defendant number 2. Against defendant number 2, the suit is abated, there is no question.
Question.
Because there is
But
no.
my
At best,
I
it
try
will be
to
executed
yes.
against 2.
I try to satisfy your lordship that 2 defendants, if same claim, same their claim may be different, there may be late difference evidence, but since one defendant expired, their legal representative not being on records, the suit is to be abated as a whole, not against only defendant number 2. This is I try to satisfy your lordships. Now, lordship can see that 2002,
No,
14.
that test has been given by the judgment which you have cited.
Yes.
That
Earlier.
Sunkara Lakshmi Narayan.
Yes.
Where
Budram versus, my lord, this is Bansi, the earlier judgment which he has referred.
not Pudram also.
About the civil matter, it is very difficult to deal for us. Now, lordship,
No, your submission is that due to non-substitution of legal heirs of respondent number 2, entire suit abates.
yes,
That is the subject.
yes,
That is the question
yes,
to be decided in
yes,
this.
yes. That is to be question, and that is why issue number 2 has been clear.
And how entire suit abates? What is your
Because
reasoning?
the reasoning, my lord, we are in position, whether wrongful or permissive, anyway, it is not a matter.
No, this suit is for declaration of right title and interest,
And recovery of position.
recovery of cash
Such
possession,
position.
where there is no counterclaim from your side.
Yes.
You have not raised any
Any
counterclaim.
counterclaim. Counterclaim is different. I am not.
No, you took the plea of adverse possession
Yes.
in the suit.
Adverse position as well
Adverse
as.
possession was
Nullified.
nullified
Yes.
by the trial
the
court
courts.
as well as by the
First
appellate
Appellate
court.
court.
Now suppose you two are possessing, one has died. One has died. It is a question of wrongful possession also only.
Yes.
Now, if the decree is granted in favor of the this present respondent,
Yes.
if he, while executing the decree, if he goes to the suit land, if he finds you or your representative, that decree will be executed against you. And suppose any of the legal heirs of the
Are found.
two are found,
Found.
they may resist the decree,
Decree, yes.
but it is separable because decree is against you.
Against the defendant number 2.
It is
Against-
not that by not passing the decree against defendant number 2, decree against you cannot be executed.
yes.
Where is the bar? If there would have been any bar that by not passing decree against defendant number 2, the decree against you also cannot be executed, then the question would have been different.
My lord, my lord, only question is this, my lord. When suppose defendant number will get a chance to contest the case, late evidence, then maybe the suit may not be decreed. It is possible to dismiss the suit, may not be decreed. We did not get that chance. That is why, my lord, it is whether I am in permissive position or illegal positions, whether it is not a matter.
No, my
is-
query is whether your defense was dependent on
One and
anything
two.
on defendant number 2, or you defended independently, though you both of you filed a joint
Yes,
statement.
yes, common.
And one of the plea
Expect.
by the defendant number 2 was you allowed defendant number 2 to
Stay in that-
occupy that land. Defendant number 2 said in his WS that somewhere it has been
Yes, yes,
stated
that one allowed.
that
It is
one
there.
allowed defendant number 2.
But.
So that means
but-
whatsoever
yes,
rights the
but
one will have,
now question
two
is, my
will
lord,
have, his right will be restricted to that one. He cannot have any excess right.
that question is, my lord. Suppose I allow one person to occupy with me. My lord, WS file jointly. But evidence part is to be different. I may submit my evidence, lead my evidence. I may establish my case that no, I am not a permissive position. I am not the persons
No,
allowed
but
the defendant
defendant
number
number-
1. We did not get good chance.
No,
That is why.
but defendant number 2 cannot go beyond his pleading. In WS, he pleaded that he is occupying the suit land
As
through
allowed.
you
Yes, you.
as allowed by defendant number 1. And defendant number 1's plea is that I am having adverse possession.
Now, Lordship, I have taken the plea that in the appeal also that legal here is not subject. It's up to Lordship to give a finding on that. That if a decree will be executed against the defendant number, I have no objection at all.
No.
But I just
no,
placing your Lordship that
just
facts.
placing would not do. You have to reason it out. So
Yes.
you are helping me only.
Yes.
So
Then, my
that
lord.
I understand.
Yes. Now, Lordship, kindly see that judgment.
So I want to understand your reason,
Yes, yes,
why
yes.
you are saying that it
Yes,
is
yes,
not
yes.
separable.
Yes. Then, my
Without-
lord,
Your submission is without impleading the legal heirs of defendant number 2,
suit is abated.
suit is abated.
Yes.
Suit cannot be decreed only against
Yeah,
the
one,
defendant
yes.
number 1.
Against, and it
On-
is also against dead person. Cannot be passed against dead person.
No, against dead person it is.
I have taken a play. Suit cannot be decreed against the dead person.
No, that is the question. Suit has already abated against defendant number 2.
So
Now, whether the suit is of such nature that relief separate relief cannot be, it is inseparable. That without the existence of defendant number 2, a decree cannot be executed against the defendant number 1. That is the
As
question.
far as judgment, it can be accepted, defendant number 1, it is no problem, but so far as defendant number 2, my submission is that it should be evident as a whole, because since no suit has been not decided against the dead person, the defendant number 2. That is why I am making such submission.
That had the defendant
got-
number 2 been interested, he would have pursued this appeal.
No,
And
how he will
How,
proceed.
my lord?
He died.
he means he or his legal
How I,
representative.
it is your
No,
duty, you
this is
living
a-
together.
This is a wrong fallacious submission,
No, they-
because unless you implead them,
Yes.
how he will know that there is
No,
a
my lord, in a place like Jorhat, my lord, the predecessor in interest of this, my lord, the defendant number 1 had filed a suit. They knew that suit is pending. This is a litigating property.
No,
So in
they
that
also
case-
knew that if you do not implead them, the suit will abate against their predecessor.
Yes, my lord, your lordship may record my submission that against this defendant number 2, the suit has abated and it cannot be executed.
My lord, see,
Your lordship
the
may record my
plaintiff, my lord, the plaintiff is residing near to the disputed land, near, in another plot of land. He is not, he have no knowledge about the expiry of that defendant number 2, my lord. Very cleverly he has not make
That is why if he has done anything
That is why I
cleverly,
make
he will
mention in the
suffer, my
appeal,
lord.
he cleverly,
Law will
he has
take its own
cleverly, my
course.
lord. The law
will
is
take
that,
its
my lord,
course.
if he is not implemented, it should be dismissed. Suit should be dismissed. Intentionally, he has not made party, my lord. He is living near to the suit land. He has the full knowledge. That is why I am submitting, my lord. Very cleverly, they did not bring on record the legal terms of the
That is why
defendant
if
number
he has
2.
done anything cleverly, mischievously, he will suffer. Why you are worried? If
No, my lord, it is not a, he have taken a wrong play, I will suffer. It should not be allowed.
Okay.
Law is clear, my lord.
Okay.
Law is clear. That is why I given that judgment, my lord. Illustratively see contact of the plaintiff. My lord, 20914 SCC, my lord. In this case, my lord, after knowing, they know very well, but after knowing that, they file a petition for submission after pronouncement of the judgment. 20914
SCC
294.
Sarah?
Now you also get the para, many para is there, but now I page para 23, I am starting from para 23, my lord. As notice herein, a plain reading of order so and so, who clearly shows that the court is empowered to exempt a plaintiff from the necessity of substituting the heirs a legal representative of any such defendant who has failed to file a written statement or who having filed it, had failed to appear and contest the suit at the time of hearing on the same. But such an exemption can only be granted before the judgment is pronounced, and in that case only, it can be taken against the said defendant, notwithstanding the date of such defendant. Such a degree shall have the same force and effect as if it was pronounced before the date had been taken place. Mr. Swensu, 24. Senior counsel appearing on behalf of the appellant, relying on the decision of Swensu, argued that since an application for exemption, the plaintiff from bringing on record the heir and legal representatives of the defendant was filed in the present case, but in view of the fact that exemption under order 22 rule 44 was not allowed in the above mentioned decisions and in the above said decisions, now no such permission was sought or granted by the court. The High Court was in error in holding that the decree passed in the suit for specific performance of the contract, but the trial court was a nullity. 24. We are unable to accede to this submission. Mr. Ranjit Kumar, the learned senior counsel appearing on behalf of the appellant, for the simple reasons. Number 1. On the abatement caused on the date of the defendant, the suit automatically abated in view of the provisions of the so rule 43 CPC. 2. From the decision of so it would be evident that no exemption was sought or granted under so CPC in the above said decisions. In any view of the matter, Order 22 Rule so clearly says that such applications to bring on record the heirs and legal representative of the deceased would be taken or granted by the court only before the judgment is pronounced and not after it. In view of our discussion made herein above, and after going through the provisions under so a discussed herein earlier, and a view of the principle laid down by the above decision, it is therefore clear that if exemption which is provided under so is obtained from the court before the delivery of judgment, in that case, it would be open to the court to exempt the plaintiff from bringing on record the heirs and legal representative of the defendant, even if the defendant had died during the pendency of the suit, as if the judgment was pronounced by stating that the defendant was alive, not to stating the date of such defendant, and shall have the same force and effect as if it was pronounced before the date of taken place. That being the positions, we are therefore view that since this case admittedly exemption was obtained after the judgment was pronounced, the provision so would not be attracted. In our opposite decision on so can also be distinguished on fact noted here above. In that decision, the plaintiff did not seek permission of the court under Order 22 Rule so, and in that view of the matter, this court held that the legal representative of the deceased defendant was entitled to be brought on record in the suit. Admittedly, in our case, after the judgment was pronounced, the permission was sought to exempt the plaintiff from necessary of substitution, the heirs and legal representatives of the defendant, and not before it. That being so, the position, we do not find any ground to rely on this judgment of this court as sought by Johnson Kumar Swensu. So, my lord, in that case, they not even take steps after pronouncement of judgment also in appellate court also, my lord. They should have get a chance to file a petition here also to bring on record them, my lord. That has also not been done. Now, in due to the 8 method, in view of the above also expressed by the Madras High Court in Swensu, in which the Swensu. The 29 and 33.
Which?
29.
Which judgment?
That
Same.
Same judgment. For the reasons above said, we are of the opinion that the High Court has rightly interpreted the provision of Swensu and accordingly held that the decree passed by the trial court on Swensu was a nullity in the eye of law, as the defendant had died during the pendency of the suit for specific purposes of the contract for sale, and no objection was sought at the instance of the plaintiff to bring on record the heirs and legal representative of the defendant before the judgment pronounced.
How many defendants were there?
Sole dependent.
Two defendants.
Sole defendant. This is a different case.
There's a different, that is why. If the sole dependent dies,
If
then
sole dependent die,
yes,
suit will abate unless. you-
abate.
Here the question is whether suit will abate only against defendant number 2 or the whole suit will. That is the question.
Because order 22, my lord, it clearly says that if it is not substituted,
No,
the word
no.
is against that defendant or so.
Yes.
And this issue has also been settled by judgment of Constitution Bench of the Supreme Court.
No, the statute is also clear.
Clear, yes.
Well, in relation to judgment for my satisfaction, At least,
একটু কালরা নেবে অমরজিৎ সিং কালরা নেবে যাইবেন অমরজিৎ সিং কালরা
না,
আচ্ছা
তাই আরো প্রশ্ন একটু মোটা কেস থাকে। আরো কাছে মোটা আছে। মোটা আছে। আচ্ছা, only one husband I have not there. It is 2021 for SCC 246
21
Benigala Koteshwarama versus Malampati Shazama and others.
What is,
Here first I reading the Just I
You
read it
read.
and then I pass
Slowly,
over.
slowly.
Civil Procedure Code 20, Order 22, Rule 439 suspension. Date of one of several respondents during pendency of appeal. Non-substitution of legal representatives of deceased respondent. Abatement of appeal due to not only qua deceased respondent but as a whole.
Yes, under what circumstance?
Yes. When take place? Suspension, distinct suspension. Now paragraph 42.5 and 43.
Twenty-one.
44. 40. Mm, 42.5. Just I finding. Of course, the provisions have been made for dealing with the application for substitution filed belatedly, but the same need not be elaborated in the present case because it remains an admitted fact that no application for substitution of legal representative of this so was made before the High Court. Here also. Now, it is admitted position, they are not making it file in the petition. Now, 44. Para. Admittedly, steps were not taken for substitution of the legal representative or defendant number 2, exactly some my defendant, who was respondent number 3 in so. Therefore, sub-rule 3 of Rule 4 of Order 23 of the Code directly came into operation, and the said appeal filed by the defendant number 16 to 18 abated against the defendant number 2, we may profitably recapitulate at this juncture that, in fact, the other appeal filed by the defendant number so was specifically dismissed by the High Court as against the deceased defendant number 2. Once it is found that the appeal filed by the defendant number so abated as against defendant number 2, the question arises as to whether that appeal could have proceeded against the surviving respondent, i.e. the plaintiff and defendant number 1 and 2. For dealing with this question, we may usefully refer to the relevant principles concerning the effect of abatement of appeal against one respondent in case of multiple respondents as enunciated and explained by this court. 44.2. The relevant principles were stated and explained in depth by this court in Punjab in Nathuram. In that case, the Punjab government has acquired certain pieces of land belonging to two brothers jointly. Upon their refusal to accept the compensation offer, their joint claim was referred to arbitration and award was passed in their favor and was challenged by the state government in appeal before the High Court. During pendency of the appeal, one of the brother died, but no application was filed within the time to bring on record of his legal representative. The High Court dismissed the appeal while observing that it had evidence against the deceased brother and consequently evidence against the surviving brother too.
Which para you are reading?
44.2.
Yes.
Now 44.3. While dismissing the appeal and affirming the view of the High Court, this court in Nathuram case enunciated the principles concerning the effect of abatement and explained as to why in case of joint and individual decree, the appeal against the surviving respondent cannot be proceeded with and has to be dismissed as a result of its abatement against the deceased respondent.
No, that means the decree has to be a joint and indivisible decree. In this case, whether that is the case, on that you have to make submission that in this case also, the decree was indivisible decree. It could not have been executed without executing it against defendant number 2.
But here, paragraph 44.2 clearly defended that it should be evident as a whole, not only for the
When?
paragraph 44.2.
Read again 44.
The relevant principle was settled and explained in depth by this court in state of Punjab versus Nathuram. In that case, the Punjab government had acquired certain piece of land belonging to two brothers jointly. Upon their refusal to accept the compensation offer, their joint claim was referred to arbitration and award was passed in favor of that was challenged by the state government in appeal before the High Court. During pendency of appeal, one of the brothers died, but no application was filed within that time to bring on record his legal representatives. The High Court dismissed the appeal while observing that it had evidence against the deceased brother and consequently evidence against the surviving brother too. The order so passed by the High Court was questioned before this court in appeal by certificate of fitness.
Because the land was belonging jointly by both.
Here also we are jointly. Here's my brother. Here also we are jointly. We are jointly occupying. Here also maybe trespasser, maybe somewhere, my lord. We are jointly occupying the land. That question will not arise if they substituted them, my lord.
No, the
This question will not arise.
question of jointly occupying and jointly owning is different.
So those are my submission, my lord. We will see. This is the matter, and
You are relying on 44.2.
I pass over.
Yes. You have any submission?
Yes, please.
Do I submitted my lord? Appeal may be allowed, degree may be set aside, and it remain back the matter to the court below. Let they bring on record the whole defendant. Then it will proceed, my lord.
But my respectful submission would be, my lord, as the defendant number 2 has expired and he has not been substituted. Now, what I could understand from my learned friend's submission, he wanted to submit that as the 2 has not been substituted, so it means this is a decree against a dead person. So if it is a decree against a dead person, that being a nullity, the entire suit should go. if I would have correctly understood the argument. So that is his argument. Now, let order 22 rule 4 says, which says that regarding substitution. Now, the statute is, my lord, very clear in this regard that when a suit would abate. Rule 4.
Yes.
Procedure in case of death of one of several defendants or of sole defendant. Well, where sole defendant dies, non-substituted suit goes. There is no dispute. Now it says, my lord, where one or two or more defendant dies and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or surviving defendant dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representatives of the deceased defendant to be made a party and shall proceed with the suit. Now, one of the defendant or plaintiff has expired, an application has to be made for substitution of the legal representatives of the deceased plaintiff or defendant. Now, suppose no application has been made, then what would be the effect, my lord? Now, rule 4, sub-rule 3, my lord, it says, where within the time limited by law, no application is made under sub-rule 1, the suit shall await, now the word is shall, the suit shall await against the deceased defendant. Now, my lord, the statute said that if one legal representative of the defendant is not substituted, it will abate against that deceased defendant. Now, the question for ascertaining the question of abatement, it has to be seen whether the decree is divisible or it is inseparable, whether it can be separated or not. As your lordship has very correctly pointed out, that if a decree is passed, it will be executed against the defendant number 1 and it will not be executed against the defendant number 2 because of this abatement. The suit is abated against the defendant number 2. Now, what is the pleading of the defendant number 1 and 2? The defendant number 1, all along it is the pleading of the defendant number 1 that he has acquired adverse title by way of adverse possession. He has been possessing this land, everything he has taken. But only the defendant number 2, his statement is, my lord, just because it is a written statement, the lordship will find at page 77. At page 77, para 13, my lord, of the memo of appeal, that the statement made in para 25 and 26 of the plaintiff are admitted, that those in para
13 of
13 of the memo of this written statement, joint written statement filed by both defendant number 1 and 2. It starts from page 74 and this para 13 is at page 77. Starts from page 74 of the memo of appeal.
Yes.
And page 77 is the relevant paragraph, my lord, para 13. Lordship got it, my lord?
Yes.
Yes. That the statements made in para 25 and 26 of the plaintiff are admitted. Those in para 27, thereof being matters of law, do not warrant any reply. It is also admitted that the defendant number 2 came to occupy on part of the a part of the suit land as allowed by the defendant number 1. Except, my lord, this pleading, and this is whose pleading, my lord. Defendant number 2 doesn't say that I come or he came. 1 says, lordship will kindly see the language. It is also admitted that the defendant number 2 came to occupy the part of the land as allowed by the defendant number 1. Now, if that be the position, what would be the right of 2? It would, that means 2 has stepped into the shoes of 1. Whatever would be the right of 1, he would be under him. Now, we may say that he is an agent, representative, or so, because normally in suit we say by evicting the defendant, he is man, agent, servant, so and so and so. So the other submission would be, my lord, if we say that 1 had allowed, my lord, before going to that submission, I'd also like to take your lordship to para page 69 of this memo of appeal. Page 69. This is
yes.
This is the, my lord, para 28 of the plaint. The defendant number 2, who is Kobiraj and practicing in Kobiraji medicine, was inducted and allowed to construct a kacha house on part of the suit land by the defendant number 1 on or about the year so and so, since the defendant number 2 is residing in a part of the suit land along with his family and practicing as Kobiraji by constructing a thatched house, who is also a trespasser there and so on. Now, in the written statement, your lordship will find no reply has been given to this para 28. At page 70, my lord, page 60, no, my lord, sorry. Page 77, your lordship will see down below which para 25, 26, lordship has seen that they have given a reply to para 25, 26. And next para, page 78, that para 29. So that means regarding the pleadings of the plaintiff, which is made in para 28, which specifically deals with the defendant number 2, has not been replied. So neither replied nor denied. So, my lord, it amounts to an admission. Facts admitted need not be proved. So these they have not said anything. So regarding defendant number 2, because a learned friend is relying on the death of defendant number 2, except for a statement which your lordship has seen at page 77, there is not even a single whisper regarding the defendant number 2. Now, the defendant number 2, apart from filing this joint written statement, he has not taken any steps in this case. Neither he has adduced any evidence, either of himself or any other person, nothing. So,
Yes.
at best, my lords, this defendant number 2 could be said to be a licensee. Now, licensee, the rights of a licensee evaporates with the right of the grantor of the license. Let us, because it is admitted that one says that 2 had allowed him to stay in that case, in that land. One was claiming ownership of that land by right title interest and he is in possession. As he was in possession, he had allowed someone else, that defendant number 2, that you come and stay in this land. So at best, he could be a licensee, and therefore, my lord, the right of a licensee will exist only till the right of the grantor exists. So, my lord, licensee is, my lord, section 52 of the Easement Act, my lord. It says that what is a license, my lord? We have quoted the details. Yeah, he quoted the Section 52, man. License defined, where one person grants to another or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor something which he would, in absence of such right, be unlawful, as such right does not amount to an easement, so and so, and is right a license. So this one says that he was in possession, he is claiming that, see, I am the owner of that land by way of adverse possession, because at that time this issue was not decided. He says that you come and stay. So one presumed that he is the owner, so therefore he has allowed to stay in that land. So at best he can be a licensee. So, and the right of the licensor, my lord, evaporates with the right of the grantor. Now, regarding, my lord, this abatement, I'd like to, my so now, my lord, now this is a আপনি 33272 2003 3SCC 272 আপনি
What is this?
this is 2003 3SCC 272 পড়েছিল তো আপনি আমার It's 2003 3SCC 272, my lord. This is a constitutional bench judgment. And my lord, this issue of abatement has been dealt in this case. Now, my lord, I have highlighted some relevant portions. Now, if you, my lord, para 27, page 17. Highlight para, sir. That's what got it, my lord. Yes. Para 27. Laws of procedure are meant to regulate effectively, assist and aid object of doing substantial and real justice and not to foreclose even an adjudication on merits of substantial rights of citizen under personal, property or other laws. Procedure has always been viewed as the handmaid of justice and not meant to hamper the cause of justice or sanctity or sanctify miscarriage of justice. A careful reading of the provisions contained in Order 22 CPC as well the subsequent amendments thereto would lend credit and support the view that they were devised to ensure their continuation and culmination into an effective adjudication and not to retard the further progress of the proceedings and thereby non-suit the others similarly placed as along their distinct and independent rights to property or claim remain intact and not lost forever due to the death of one or other in the proceeding. The provisions contained in Order 22 are not to be constituted as a rigid matter of principle, but must ever be viewed as a flexible tool of convenience in administration of justice. Then your lordship will come to my lord. Page 22, my lord. That highlighted portion at times. Yes. And here is what had happened. One had occupied the land illegally. One had allowed two that you stay in that land. Now it says at one or other parties, at times, one or other parties on either side in litigation involving several claims or more than one pertaining to their individual rights may settle among themselves the dispute to the extent of their share or portion of rights are concerned and may drop out of contest, bringing even the proceedings to a conclusion so far they are concerned. If all such move is allowed to boomerang adversely on the rights of the remaining parties, even to contest and have their claim adjudicated on merit, it would be travesty of administration of justice in itself. Then, my lord, para 34. Now, same is in this case because I am.
How many judgments
But
are-
5 minutes, hardly 5 minutes. One more judgment, I'll continue. One more judgment of this.
I have no objection, maybe.
Only 5 minutes. Madam. This paragraph and one this judgment.
No, if you want to take more time, I
No,
can.
no, hardly 5 minutes. This highlighted portion and one portion of our judgment of our High Court, my lord. Then.
Okay.
Now, in this case also, because I am submitting, why I am, my lord, so
Okay.
confidently submitting before your lordship that if we will not be executed against two, then because of this, because ground reality, we know that two is dead. He had one daughter. They had various properties. They have left it.
Okay,
That is why exactly the Supreme Court has said it.
not more than 5 minutes.
Yes, my lord. My time starts now. Yes, para 34, my lord. Even assuming that the decree appeal against or challenge before the higher forum is joint and severable, but dealt with rights of more than one recognized in law to belong to each one of them on their own and unrelated to others, the proceedings event in respect of one or more of either of the parties, the court are not disabled in any manner to proceed with the proceedings so far as the remaining parties and part of the appeal is concerned. As and when it is found necessary to interfere with the judgment and decree challenged before it, the court can always declare the legal position in general and restrict the ultimate relief to be granted by confining to those before the court only, rather than denying the relief to one and all on account of procedure lapse or action or inaction of one or other of the parties before it. Then, my lord, the next page, as far as possible, my lord. As far as possible, the court must always aim to preserve and protect the right of the parties and extend help to enforce them rather than deny relief and thereby render the rights themselves to IOTs. Now, in this para 35, the court has summarized, and this judgment, my lord, has been referred to in several judgments of the Supreme Court. This is a constitutional bench judgment. So it says that, my lord, the court should, because the lordship has in the other case, that 66 of 94, the right regarding that other sale deeds and my sale deed, the court has decided, my lord, that issue has been dealt with. Now, suppose if it is held that, my lord, because of death of two who is no longer in the scene, the entire suit goes, my lord, then it will be against the spirit of, my lord, this dispensation of justice. Now, my lord. Now, relying on this is judgment of our High Court, my lord. Relying on this judgment of constitutional bench, this Kalra, my lord, Amarjit Singh Kalra, my lord, here also, my lord, court has said, here had happened, the two had not filed, my lord, the two was defendant number two was the pro forma defendant, no relief was sought against pro forma defendant, and the pro forma defendant had not filed any counter claim also. Now, in my lord, para 14, my lord. Para 9 will see from the contention, page 4, para 9, my lord. What was the issue before this court? Page para 9, page 4.
Yes.
Yes. From the contention so raised by the parties, the question which arises before this court is as to where the appeal awaits as a whole for non-substituting some of the legal representatives of the original plaintiff in the appeal, and as to whether non-substituting some of the legal representatives of original defendant number two would be fatal to the adjudication of the appeal. So this was the issue. Then your lordship will kindly come to, my lord, para 14. As regards the second question as to whether the appeal would abate for non-substituting the legal representatives of so-and-so, so-and-so, and so-and-so, who are all the legal representatives of original defendant number two, it is relevant to take note that the suit was filed for eviction of the defendant number two, and there was no relief whatsoever claimed in the defendant number two. A perusal of the written statement of the defendant number two shows that he had claimed an independent right over the suit property supporting the case of the defendant number one. Para 14, my lord. 14. Para 14. I'll again read it.
No.
As regards the second question as to whether the appeal would abate for non-substituting the legal representatives of so-and-so, so-and-so, who are the legal representatives of the original defendant number two, it is relevant to take note should be fact, my lord, of the fact that the suit was filed for eviction of the defendant number one, and there was no relief whatsoever claimed against defendant number two. A perusal of the written statement of the defendant number two shows that he had claimed an independent right over the property supporting the case of the defendant number one, but admittedly there was no counterclaim filed by the defendant number two. It is also apparent on record that some of the legal representative of defendant number two was already on record. At this stage, it may be
Mr.
referred.
Das,
Yes.
we have to spill over. I have queries.
Regarding this. Place.
Yes, the judgments, because I queried Mr. Ahmed. I have not gone through these judgments. So instead of rushing, I'm fixing a date. You place this judgment again. I will put my queries.
Yes, my lord, it can be done.
It may be 5 to 10 minutes only.
Yes. Yeah. In that case, my lord, no
He may
relief,
have-
no
he may
relief
have-
sought, no relief sought against defendant number two.
No,
But
but
in my
there
case,
is- yes,
relief
no
sought
relief,
against the
but-
defendant
No,
number
I
two.
am giving you both of your time
My lord,
because instead of rushing, it
Yeah.
may not be proper.
my lord.
Yes.
Heard Mr.
Next week,
J. Ahmed, learned counsel for the appellant. Also heard Mr. A. Das, learned counsel for the respondent. The hearing remains inconclusive. When?
Let it be in the next week, my lord, otherwise we will also forget
Yes,
everything.
yes, next week,
it is 13, my lord.
13.
Yes.
Let this case be listed again as a part heard matter on 13/8/2024
At two,
at 2 p.m.
13
August,
At 2 p.m.
2 p.m.
I think the next more
Next month.
Yes, any,
It may be 17 months,
17 Saturday.
then 16 maybe.
16 is not a,
Then the 19 or 20.
Let it be on 13, let us see.
I have some problem.
and then let it be on 16.
16.
16 at 2.
Yes, ma'am.
16.
16 at 2 p.m.
16 is Friday, ma'am.
Okay,
No
we'll
problem.
take,
I have only 5
though
minutes.
it is not a hearing day, but we have already heard.
Yes, yes.
Only 5
Only
to 10 minutes
minutes,
may
yes.
be required.
16.
Yes.
With respect to item number 24, Lordship, the date may be fixed, Lordship. I have some urgency because the claimant, husband is suffering from ailment versus, some urgency there, Lordship.
Who is the other side?
Mr. R. Goswami sir, he was there. In the morning hours, he told me to pass over the matter for time being, but
When you want,
on 20th, if possible,
on request of learned counsel for the
respondent.
respondent, let this matter be listed again on 28/2024. Mr. Ahmed, you take this one.
Yes.
If required, we
Hello there. Yes.
retain this order.
Yes, yes, sir.
You give me on next day.
The
Or-
judgments.
No, judgment.
No,
I-
the finished stage of the application.
You write here. Give it to Mr.
I will give the photocopy.
Yes. It will go in.